653 of 2023.
It is the petitioner.
Item 6.
Are you there in this
Madam,
case?
in this case I am very
On that day somebody else was appearing?
Madam,
On the last day somebody else was appearing?
Mr. Sarvinder Kumar.
Yes. Yes, you are.
Madam, in this case also, it is not challenging the order dated also 4/9/2029 Annexure 3 at page 38 passed by the Lordship Commandant 136 Battalion BSF Your Lordship Punjab, whereby Your Lordship petitioner had been dismissed from this service, Your Lordship, for absence without leave, with effect from 4/9/2019 and also other penalty. Annexure 3 page 38 may kindly be Your Lordship.
Yes, I've seen it.
May I read?
I've read it. You just tell us. You come to the points. पिछला 3 दिन से चल रहा है.
Madam.
एवरी टाइम नया काउंसिल होने से नया आर्ग्यूमेंट नहीं शुरू होगा ना. पिछली बार हम उनको बताए थे कि क्या क्या मेरा ऑब्जर्वेशन है.
Mother of the petitioner, Your Lordship, very seriously because of this reason, Your Lordship, petitioner earned leave, Your Lordship, with effect from Your Lordship 5/5/2029 to 19/5/2029.
29 19 अभी 29
19 2019 when he was on parole, Your Lordship, while undergoing punishment of 89 days. Then ये यहाँ आप लीव पर आए. इनके मदर जो है वेरी सीरियसली बिकॉज ऑफ दिस रीजन, Your Lordship, absence is not willful, my lord. Absence is compelling circumstances.
We do not know. 19 के बाद क्या हुआ उसका कहानी सुनाइए ना.
My lord,
What happened after
19 के
19?
बाद mother of the, I have specifically stated in my writ petition, my lord.
Where are you?
Mother of the petitioner is seriously ill because of this reason. I have stated, my lord, para 6 and 7, my lord.
6 is nothing. Para 7.
Para 7, that the mother of the petitioner was seriously ill, as a case of both kidney failure and admitted in IC, and there was no one to look after her. Thus, the petitioner over stay of the leave on compelling circumstances. Unfortunately, his mother subsequently died. Thereafter, I have stated my para 8 and 9. Thereafter, petitioner reported his duty and submitted verbally, Your Lordship, he informed to the said Vahini, Your Lordship. But Your Lordship, they have not extended his leave. Before Commandant
Verbally, where do you say verbally?
my lord,
Where do you say?
thereafter petitioner reported his duty and submitted the petition before the Commandant
This
136.
is not a verbal communication.
And so my lord, my submission is absence from duty is not, Your Lordship, willful. That is the, Your Lordship, compelling circumstances because his mother is seriously ill and subsequently. My Lord, she died on, and in this regard, Your Lordship, by relying the judgment which is rendered by the Honorable Supreme Court in delivered on judgment 2012 3 Supreme Court cases 178. Make I Your Lordship.
170.
178. Para 17 and 18 and 19 is relevant. Your Lordship. If the absence is the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be difficult eventually due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, the employee can't be held guilty of failure of devotion to duty or behavior unbecoming of a government servant. 18 है जो in a departmental proceeding, if allegations of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In the absence of such finding, the absence willful not amount to misconduct. In my case, Your Lordship, not a properly departmental proceeding initiated, Your Lordship, and inquiry not conducted. इनको तो हुजूर ये करना चाहिए था, कंसर्न ऑफिसर इंचार्ज से रिपोर्ट लेना चाहिए था कि ये हमारा जो है एब्सेंटिज्म जो है वो जेन्यून है या नहीं है, मेरी मदर सीरियस है या नहीं है. ऐसा कुछ नहीं हुआ. सब्सिक्वेंटली वो डेथ भी कर गए. तो ये चीज भी ये नहीं आया है. 19 में ये चीज भी है, वो भी हमारे केस से रिलेटेड है. इन द प्रेजेंट केस द इंक्वायरी ऑफिसर ऑन एप्रिसिएशन ऑफ एविडेंस though held that the appellant was unfortunately absent from duty but failed to hold that the absence was willful, the disciplinary authority as also the appellate authority failed to appreciate the same and wrongly held the appellant guilty. This judgment, Your Lordship, fully covered in my case.
That's all. Respondent.
And a similar case, Your Lordship. In similar case, Your Lord, Vijay Kumar Urao, Your Lordship. In WPS passed by this honorable court, single bench. Said judgment is also applicable in my case.
Para number.
Para number, Your Lordship. Seven, my lord. 7 and 8. ऑनरेबल सुप्रीम कोर्ट के जजमेंट के आधार पर इसका भी जो है affiliate authority, Your Lordship, not considered.
That's right.
Then thereafter matter remitted to the quantum of punishment. इसके ऊपर quantum of punishment इसमें तो hard punishment होगी, but may kindly Your Lordship consider quantum of punishment.
Yes.
Yes, ma'am. But in this case, so far as the petitioner is concerned, he was awarded 89 days rigorous imprisonment from 14/3/2019 to 10/6/2019. during this period, Lord, he makes an application with regard to the earned leave, Lord, and thereafter, Lord, on 4/5/2019, he was granted 15 days earned leave with effect from 5/5/2019 to 19/5/2019. My Lord, thereafter he was to remain in rigorous imprisonment for 37 days, that is after expiry of the period of earned leave from 20th May 2019 to 25/6/2019. In the meantime, my Lord, he did not return after the completion of the earned leave on 20th May 2019. The notices were sent, my Lord, thrice by registered post. My Lord, on 22/5/2019, 30/5/2019, and 6/9/2019. And thereafter, my Lord, on 15/6/2019, a commission of inquiry was constituted in terms of section 62 of the BSF Act. Well, that speaks about inquiry into absence without leave. Well, it says, my Lord, when any person subject to this act has been absent from duty without due authority for a period of 30 days, a court of inquiry shall as soon as practicable be appointed by such authority and in such manner as may be prescribed, and such court shall on oath or affirmation administered in the prescribed manner inquire respecting the absence of the person and the deficiency, if any, in the property of the government entrusted to his care and arms and so and so, so and so. Already in terms thereof, Lordship, kindly come to page 37, Lord. The commission of inquiry has been conducted, Lord, and the finding of the commission of inquiry is appearing, Lord, at page 37, opinion of the court. Well, the point which has been argued by my learned friend with regard to the finding that it was not intentional, my Lord, that has been given, that I intend to submit before Lordship, Lord. After having gone through the statement of the witnesses and relevant documents, the court is of opinion that Dharamraj Bhagat so-and-so, who was undergoing punishment for RI for 89 days in the forced custody, proceeded on 15 days EL and was supposed to report back on 20th May 2019 forenoon, but did not report. After OSL, he was informed in written thrice with direction to report back to unit immediately, following which he will be treated on OSL and overstay leave, and disciplinary action would be taken against him, but did not report to the unit till date. In spite of the repeated correspondence, neither the individual informed or delayed report nor he requested for any extension of his leave. As the individual is habitual of overstaying the leave and absent without leave, and he is overstaying the leave without any information or prior permission from the authority, otherwise he should have requested for extension of leave. It clearly shows that he overstaying the leave intentionally and without sufficient cause. So, keeping in view of fact, the recommended the following: a so-called notice may be issued to the individual. Strict disciplinary action, administrative action applicable as per the BSF Act and rule may be taken against the individual, all due so and so. In pursuance thereof, Lord, on 5/8/2019, the so-called notice was issued to the petitioner, and subsequently, my Lord, the impugn order has been, with regard to that part, has been passed, my Lord. Therefore, so far as the entire procedure which was applicable to the petitioner in absence, with regard to the absence that has been followed before passing the impugn order, my Lord, and there is no illegality in the procedure. So far as the explanation which is required to be submitted by the petitioner, my Lord, after 20th May 2019, there is no such explanation with any documentary of it.
My Lord, in absence of your Lordship, petitioner conducted your Lordship inquiry and opinion of the court was given, your Lordship. And ये कह रहे हैं कि sufficient cause हुजूर इंक्वायरी कंडक्ट करके लिया जाता तब तो sufficient cause आता हुजूर.
आपके पीछे पीछे घूमते रहते.
नहीं, हमारे पीछे नहीं, हमारे मदर सीरियसली.
आपको बहस सुन लिया, अब आप ऑर्डर सुन. WPS number 1653 of 2023. Heard the learned counsel for the parties.
Well, I am taking leave.
This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that petitioner has been dismissed.
Appellate authority also not considered.
The counsel for the petitioner has submitted that the petitioner has been dismissed from service on account of absence without leave. But absence without leave, but the authorities have failed to consider that the absence is not willful. Rather, the petitioner had applied for leave on account of illness of his mother for the period from 5/5/2019 to 19/5/2019, and thereafter he did not report back for duty on account of compelling circumstances. He has referred to paragraph 7 and 8 of the writ petition, which are quoted as under. The Learned Counsel has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2012 bracket close 3 SCC 178 within bracket Krishnakant B. Parmar versus Union of India, paragraphs 17, 18 and 19, which are also quoted as under. He submits that he has also relied upon judgment passed by this court in WPS number 3313 of 2015, Vijay Kumar Orao versus the Union of India, dated 17/12/2021, and has referred to paragraph 7 thereof, which is quoted as under. He submits that the matter in WPS number 3313 of 2015 was remitted back to the authority for a fresh order on the quantum of punishment. The Learned Counsel submits that proper inquiry was not conducted, and therefore the impugned order is fit to be set aside. He has also submitted that without prejudice to the aforesaid submission, the punishment of dismissal is harsh and shockingly disproportionate, and therefore the matter may be remitted for passing an appropriate order on quantum of punishment. The Learned Counsel has also submitted that these aspects of the matter has not been properly considered by the appellate authority. Also, and therefore the appellate order is also fit to be set aside. The Learned Counsel, appearing on behalf of the respondents while opposing the prayer of the petitioner, has submitted that the petitioner was undergoing punishment of 89 days rigorous imprisonment with effect from 14/3/2019 to 10/6/2019 in forced custody, and during this period he applied for earned leave of 15 days with effect from 5/5/2019 to 19/5/2019 on parole. But thereafter he did not report for duty. Consequently, a show cause was issued Consequently, court of inquiry was set up, and consequently 3 registered letters were sent to the petitioner at his home address with a direction to resume duties, but he neither resumed duty nor gave any reply. And a court of inquiry was set up, and after considering the materials, it was reported that the petitioner is habitual of overstaying the leave, and he was absenting without any information or prior permission from the authority. Otherwise, also he should have requested for extension of leave. His conduct showed that he overstayed the leave intentionally and without sufficient cause. And in such circumstances, it was directed that a show cause notice be issued to the petitioner to report back to duty. But in spite of that, the petitioner did not report back for duty, and ultimately the petitioner has been terminated from service. The learned counsel submits that the procedure, as per the provisions of section 62 of VSF Act 1968, has been followed, and there is no procedural irregularity. The learned counsel has also submitted that vague statement has been made in the writ petition with regard to illness and death of his mother. The petitioner had also filed appeal, and appeal was also dismissed. The learned counsel has submitted that the impugned orders do not call for any interference. After hearing the learned counsel for the parties and considering the facts and circumstances of this case as placed on record by the writ petitioner, it is not in dispute that the petitioner was undergoing punishment of 89 days rigorous imprisonment with effect from 14/3/2019 to 10/6/2019, and he was granted earned leave with effect from 5/5/2019 to 19/5/2019 on parole. And the remaining portion of rigorous imprisonment, that is period of 37 days, what was to be undergone by the petitioner with effect from 25/2019 to 25/6/2019 on joining from leave. After expiry of leave, the petitioner was required to resume his duty on 19/5/2019, but he failed to do so. impugned orders also reflect that 3 registered letters were sent to the petitioner at his home address with direction to resume duties, but he neither resumed duty nor gave his reply. From the perusal of the writ petition, this court finds that it is not the case of the petitioner that the petitioner did not receive any of the registered notice issued to him. It further appears from the impugned orders that the petitioner did not respond to any of the registered notices and neither sought any further leave, and accordingly neither sought any further leave nor informed the authorities regarding absence from his duties. This court further finds that the impugned orders reveal that, as per the provision of section, this court further finds that ultimately this court further finds that, as per the provisions of section 62 of BSF Act 1968, a court of inquiry was ordered, and after completion of court of inquiry, the petitioner was called upon to show cause against the proposed action of termination, to which the petitioner did not respond. And failed to avail of such an opportunity. In the writ petition, the petitioner has taken a stand in paragraphs 7 and 8 as quoted above, that the mother of the petitioner was seriously ill, as on account of both kidney failure, and was admitted in ICU, and ultimately and subsequently she died. He has also stated that, however, no document in connection with the illness of the mother of the petitioner, nor any detail regarding the period of illness or even the death certificate of the mother of the petitioner has been placed on record, even to prima facie substantiate that the petitioner was attending his mother after 19/5/2019. He has further stated in paragraph 8 that he reported his duty and submitted the petition before the Commandant 136 BN BSF along with medical certificate regarding treatment of his mother. But neither such petition nor any medical certificate has been brought on record. The fact remains that the petitioner did not respond to any of the registered letters which were said to have been served upon the petitioner asking him to join for duties. This court is of the considered view that certainly all absence from duty are not to be treated as willful. If there is some explanation from the side of the incumbent regarding his absence. However, in the present case, the petitioner neither reported for duty in spite of notices, nor gave any intimation to the authorities regarding his absence or for extension of leave. Accordingly, this court is of the considered view that the authorities have rightly dismiss the petitioner from services, and the judgments which have been relied upon by the petitioner by the Honorable Supreme Court as well as by this court in WPS number 3313 of 2015 does not apply to the facts and circumstances of this case. This court also finds that the petitioner filed appeal and the appellate authority has the petitioner has not even annexed a copy of the memo of appeal filed by the petitioner along with the writ petition to bring on record the grounds on which the appeal was filed. However, from the perusal of the appellate order, it appears that the appeal has been dismissed considering the materials on record, and it also appears from the appellate order that the appeal was filed beyond the period of limitation. No argument has been advanced by the petitioner in connection with the delay in filing the appeal, and no explanation has been mentioned in the writ petition with regard to delay. Considering the totality of facts and circumstances of this case, this court finds no merit in this writ petition, which is accordingly dismissed. ये किताब साथ में रखो।
Under heading for orders, item for WPS 1927 of 2023.
Sorry? I don't get that. What do you want?
CRMP 15/11/2023 की केस है ऐश्वर्या श्री स्टेट ऑफ झारखंड, तो मैं चाह रही हूँ कि फिक्स्ड टाइम मिल जाए, आज ही करेंगे।
ये तो आप you don't want to do this case.
But I want
This is writ petition, no? Is it your case?
ये आइटम 19 के बारे में बोल रही है।
ऐसे आप कभी भी खड़े होकर मेंशन नहीं कर सकते। ऐसा नहीं होता। Please don't. You are an advocate. Please behave like an advocate. Litigant की तरह मत बनिए। ऐसा नहीं कर सकते ना, आप कभी भी घुस के मेंशन करेंगे।
अभी पहले ही आई थी, बट केस स्टार्ट हो गया, टेकअप हो गया।
बहुत अच्छी बात है। जब आपका टर्न आएगा तब मेंशन करें। Who is for the petitioner in this case?
Is the court also. But on the last occasion was it was listed, I was seeking for a short passover, but my senior is
Rejected. You argue your case.
May I assist, madam? My lord, short point for my lord's kind consideration in this matter. The advertisement that was there, madam, that was for the examination for PGT teacher only. 75% was to be recruited through direct examination, and 25% was limited for the primary teachers with certain experience. And notification advertisement itself revealed the post position, the dispute propped up in this matter on the basis of the fact that 100% reservation was effectuated in the scheduled area for the local resident. So that was challenged, being ultra-virus to Article 16, and the petitioner therein succeeded, and that part of the advertisement was struck down. An entire advertisement rather was set aside for a new process of it.
For a new process.
Yes, that was travelled to Honorable Supreme Court.
It was not a completely new process.
No, what Supreme Court, I am just placing that judgment from Soni Kumari. Two paragraphs I will refer from here.
Paragraph.
Paragraph 27 I will be placing just a moment. That is the finding part, madam.
That will be at page 103, ma'am.
Yes.
May I place this paragraph in entirety? However, at the same time, and the facts and circumstances of this case, and more particularly by quashing and setting aside the appointment already made, there is likelihood of more complications, which would not be proper in larger public interest. Hence, we are of the opinion that this is a fit case to mold the relief. Apart from this, the fact that the appellant herein selected candidates belonging to scheduled districts areas are already working since last about 3 years. In case appointments already made are not protected, then thousands of schools in the state of Jharkhand would be without teachers, and ultimate sufferers would be the children of tribal areas. In view of the impugned judgment, an order passed by Honorable High Court, by which the High Court has held all appointments made in scheduled areas illegal and has further directed to go for fresh recruitment, the state will have to undergo fresh recruitment process, which may take considerable time, and in the meantime there shall be vacancies, and number of schools in the tribal areas shall be without teachers. Therefore, the court has to strike a balance between the rights of the original petitioner as well as person teachers already appointed, whose appointments are held to be illegal, and also the public interest. Hence, we are of the opinion that while molding the relief, instead of initiating a fresh recruitment process, if directions are issued for preparation of fresh selection list based on revised merit list and based on already published cutoff obtained by the last selected candidate in the PGT subjects against respective categories, may underline this, take note of this. It will meet ends of justice and striking the balance between the competing rights, so that persons already appointed may not have to lose their employment job, and at the same time the candidates belonging to non-scheduled district areas may also get their opportunity for appointment as teachers on merits in the scheduled district area. We are of the view that no useful purpose will be served to go in fresh de novo recruitment process as directed by the High Court in the impugned judgment order. In view of the above discussion and for the reason stated above, we uphold the common judgment passed by the High Court declaring the impugned notification so and so. The Constitution, we are in complete agreement with the view taken by the High Court. So this is what Honorable Apex Court said, that a fresh merit list be prepared category-wise and subject-wise. Now, my lord, I will be relying, because there are two different sources of employment.
Where are the other orders?
My lord?
Where are the other orders?
Yes, I am just placing. That order. Because here the court did not clarify the situation. It said that you make a merit list. Now the first is that in contempt was filed before Honorable Apex Court. That is at page 1 to 5. My lord has got. So operative part, sir. Operative part, the second page would be my lord. That the state shall prepare merit list state-wise pursuant to the application already invited. One, that the candidates who had already applied for scheduled area and they were not offered appointment in the scheduled area in view of earlier notification, which has been struck down, they may be adjusted as per earlier judgment and order dated 2/8/22. Thereafter, the appointment to be made with respect to 425 candidates who were all original writ petitioner before the High Court, as well as in whose favor subsequently some orders are passed by the High Court. Fourth, that thereafter the remaining vacant post meant for direct recruitment 75% shall be filled in absolutely on basis of merit, as well as state-wise merit list and subject-wise, and after following due procedure as required by the council. Thereafter, so far as now it is dealing with merit, the post remained vacant meant for promotion. So once it is filled, my understanding, 25% is concerned, the same may be filled in by operating the state-wise merit list in accordance with. Meaning thereby, if any candidate for the promotional quota is not available, in that case, remaining vacancy to be filled to provisos to Rule 9 of Rule 15. So in my humble submission, what is my case? We are for limited 25%.
Which district, scheduled or non-scheduled?
We had applied for Ranchi. Now my category
Ranchi falls under which?
Scheduled.
Scheduled district.
Now my submission before my lord, that they had to prepare two merit lists. One for the limited examination merit list for 25% and one for 75%. These two cannot be clubbed together because the examination advertisement and that was not struck down. And that is never the import of the judgment. For that reason, I refer to para 27 of the judgment. Now, if general merit list is prepared for 25%, I don't fall in that list. For Ranchi, I don't have any case. But my seat cannot be handed over to 75% merit list. And that is what Honorable Apex Court says, that if 25% seat is left vacant, that will be released for 75%. This relief has been molded for under 142, that if it is anything, suppose there are 100 seats to illustrate it, only 75% promotional candidates are available, then 25 seats will be released for the 75% candidate.
The same may be filled by operating the state-wise merit list in accordance with law.
Which my lord is referring to?
Para serial number
Yes,
5.
yes, in accordance with it. So far as posts remain vacant made for promotion of 25% are concerned, the same may be filled in by operating the state-wise merit list in accordance with it. Understood, my
So
lord?
merit list has to be seen state-wise.
State-wise. I am not saying for Ranchi you prepare a list. My
And
case is,
And then for
yes, meaning thereby if any candidate for promotional quota is not available, in that case remaining vacancy will be filled from proviso of Rule 9 of Rule 6. So my case is, my lord, let me, what I am trying to submit before my lord's kind consideration, the two list has to be prepared, 25% one list and 75% one list. Now if 25% list, merit list, if there is no candidate available in that merit list, then all seats will be released. If 50 candidates, suppose 100 seats are there, 50 seats is available. What they have done, now that I am coming, they have clubbed these two categories in one. And they have filled all these 25% category candidates by the direct recruit. Relying
From
on,
where do you say this?
yes, I have made a specific statement and they have not rejoined to that. I have stated, but my
Where
lord,
is it the statement?
my lord,
Where is this?
yes, I have stated. But if I am referring this judgment, my lord, two more judgment, if I place on this point that they cannot do so, simultaneously, then I will come back to the facts of this. The second judgment that I will be relying is, my lord, 1976 to SSC 901.
You don't need to go to all that. We have to stick to the direction of the Honorable Supreme Court
Yes.
under 142.
Yes.
So it will be divorce any other judgment.
Yes. It is law of land.
So there is no need to go to anything else. You just tell us,
My lord.
where have you stated that this 25% direct promotion seats
My
to
lord.
which you had applied,
My lord.
they have filled all of them from direct
Page
recruits.
21, my lord, may kindly come. Para 9. If I refer from para 8 onwards, my lord, page 20, that it is most humbly stated that while making the fresh merit list as directed by Honorable Apex Court, the respondent erred in combining seats particularly earmarked for primary teachers. Advertisement number 21 of 2016 provided for 44 seats in general category for fresh recruits and 14 seats for primary teacher in general category in the district Ranchi. The total number of seats were 58. Similarly, for scheduled tribe, 25 seats were earmarked for fresh recruits and 8 seats were earmarked for primary teachers in the district Ranchi. The total number of seats were 33. The relevant portions of the advertisement is reproduced as under. Now, I will come para 9. That, however, the respondent-wide results dated 15th March 23 gave 28 seats to the writ petitioner of WPC so and so. All candidates were fresh recruits belonging to the general category. That thereafter, wide result dated 4th April 23, the entire remaining seats of 30 seats were allotted to fresh recruits. This includes 14 seats which was earmarked for primary teaching. That similarly, in the scheduled tribe category, the entire number of 33 seats were given to fresh recruits belonging to the scheduled tribe category. This included 8 seats earmarked for primary teaching. That in light thereof, the petitioner who otherwise would have been entitled for a seats in the district Ranchi, based on preference, have been allotted seats in district Saraikela, Kasava, which was at serial number 13 and 15th in the district preference list. And this part of the advertisement has not been done away with. That in the most humbly submitted that respondents have committed gross error in combining seats earmarked for primary teachers with those of the fresh recruits. The action of the respondent is contrary to the terms of the advertisement and amounts to changing the rules of it. that it is further stated that no rationale behind the decision of the to merge the seats of the earmark for primary teacher with that of the fresh recruit, and as such the decision is highly arbitrary. So this is my case, my lord. They have not replied to this.
What is their counter?
To this, my lord, if I refer to their counter, the 5-2 counter affidavits, my lord, supplement. They have not responded, my lord. They have given a general proposition that was of the Honorable Apex Court. And from where they are reading that these two categories has to be clubbed together. When the contempt petition itself says that 25% is to be done, 75% is to be done separately.
Paragraph
32, yes, 32, yes, 28 onwards, if it is, if I place it, the first
Para
count,
27.
28
काउंटर उन्हीं को प्लेस करने दीजिए. आप अपना काउंटर प्लेस करिए.
Yes.
I am placing counter affidavit, Your Lordship, responding with 527. Para 28, page 15.
You come from para 27.
Para
27.
27. That it is stated after passing the order dated 15/12/2000.
तो para 27 तो कोई और ही है. Supplementary counter.
नहीं
दो
काउंटर
counter
काउंटर का देखा है
Main counter.
जी हम
Para
supplement
28.
28
Main counter से.
मेन काउंटर उसमें भी वही लिखा हुआ है पारा 20 that it is after passing the order dated 15/12/2022 JSC started the process to divide the
इसमें से
merit.
पढ़ रहे नहीं समझ में आ रहा. Your counter affidavit dated 14/7/23.
Probably state
Para
counter-
number 28. 27.
27.
Please continue.
May I read your notes?
Yes.
That it is said that after passing the order dated 15/12/2022 JCC started the process to follow that has been placed your lordship several times. Soni Kumari case your lordship, no contrary order etc. Your
That's
lordship. Your lordship. That is after passing the order dated 15/12/2020 JCC started the process to revise the merit list in compliance with the aforesaid order of the Honorable Supreme Court, and thereafter also issued list of the shortlisted candidates for verification of the testimonials. Next, that it is not out of place to mention that JSCC thereafter started the process to revise the merit list in compliance with the order of the Honorable Supreme Court. I have mentioned that JSCC published the revised result for appointment of graduate teacher for subject history and civics on 4/4/2023 by Direction 7 of the writ application, and thereafter also made recommendation for appointment of the successful candidate to the state government. Next, your question. That it is that petitioner number 1 belongs to ST category working teacher, petitioner number 2 belongs to EBC1 category working teacher, and they have been declared successful for appointment, and they have allocated Saraikela, Kharsawa and West Singhbhum district respectively. Next, your question. That it is said that the petitioner number 1 has secured 140 marks, and his rank in the state merit list for subject history and civics is 17344. Next, that is the last selected candidate in ST category in Ranchi district has secured 228 marks, and his rank in the state merit list for subject history and civics is 2984. Next, that it is that vacancies under ST category in the district Ranchi in subject history and civics have been filled up by the candidates of the direct recruitment. Next, that as stated earlier, paragraph
For ST category, how many vacancies were there for Ranchi?
For general, it is 74, my lord.
Where is the advertisement?
Total is 74.
Petitioner number 1 is SC?
my lord,
ST. Tell us from the advertisement.
I am just.
my lord, kindly see page 31 of the writ application.
32 पे है actually.
My lord, that is your lordship, जिला का नाम रांची. ये है रांची डिस्ट्रिक्ट your lordship.
हाँ,
Then
रांची.
your lordship kindly come to relevant is your lordship. Page 32 at serial number 13.
Page 32 at serial number 13.
13 your lordship. इतिहास और
इतिहास.
नागरिक शास्त्र.
Yes. Vacancy.
Vacancy. Your Lordship, the first column is 25, Your Lordship, that is means
That's
for unreserved.
Yes. Then 14 for
25 and
Okay.
14 is Your Lordship, ST.
14 is ST.
ST.
So you have filled up 14 teachers by way of promotion,
By way of appointed, Your Lordship.
appointed. By way of promotion.
By way of the working primary teacher category.
14 teachers from working primary, 14 ST teachers from by way of promotion.
By way of my lord. By
That's
way
it,
of
promotion only,
promotion,
fixed
fixed.
for reserved categories. For them.
Reserved category, Your Lordship.
Where
Now,
have
my
you
lord,
stated that 14 ST candidates whom you have filled from the reserved category?
My lord, I have stated, Your Lordship, because Your Lordship, after passing the order by the Honorable Supreme Court, we will have to, Your Lordship, the filled up, Your Lordship. There is no categorization, Your Lordship. That you will have
No,
to.
there are two categories.
No, my lord.
There is no-
Your Lordship is correct.
There
are
is
two
no
categories.
mixture of direct recruits and promoters.
My lord, so far the educational qualification and others are concerned, Your Lordship. So far, in the contents of the order passed by the Honorable Supreme Court, 15/12/2022, Your Lordship, my lord, all the posts was to be filled up on the basis of the state-wide merit list, and as such, Your Lordship, they have been allocated. The candidates who are above the petitioner in the state-wide merit list, they have to be allocated the merit list, Your Lordship, the Ranchi district.
The main judgment was not very clear as to what stepwise decision is required to be taken.
My lord.
That stepwise decision has come only in the contempt application.
Contempt, and my lord, the result has been published after the contempt application order.
So,
And as
so
to-
there is, first tell us one thing, where two different merit lists to be prepared for direct recruits and promotees, yes or no?
Two lists, Your
Two
Lordship.
lists.
Two lists.
So,
Because
what
Your
is the
Lordship-
position of the petitioner in the list of direct recruits so far as ST candidate is concerned? Is he below 14? And which all are the candidates under ST category, under direct recruits who have been appointed?
My lord, it appears to me, Your Lordship, the subject to Your Lordship further clarification by the petitioner. My lord, in the first list, Your Lordship, they were not appointed. In the first list, they were not appointed.
First list means
Means, Your Lordship, the prior to
direct
the,
recruit.
first
Original.
List, original, Your Lordship, before Your Lordship, the passing the order by the Honorable Full Bay, by this Honorable Court, Your Lordship.
They had
My lord-
applied under scheduled area.
Scheduled district.
They had applied in scheduled district and they are residents of also scheduled districts.
Yes, yes.
So there was no occasion to exclude their name under any circumstances.
My lord, subject to Your Lordship fulfilling the other conditions, Your Lordship.
What
If Your Lordship see Your Lordship that they are not within the zone of consideration, and otherwise Your Lordship also, then Your Lordship, they can be adjusted as per the merit list, state-wide merit list, Your Lordship. After passing
Where
the
you
order-
ultimately, you see,
They-
you had no grievance so far as Soni Kumari case is
No,
concerned,
nothing.
right?
I still.
You were belonging to scheduled district.
Yes.
You applied under scheduled district.
So due to,
So as per the advertisement, you were certainly entitled to be appointed
Yes.
for scheduled. So you had nothing to do with Soni Kumari judgment. Rather, you would have opposed it if you would have given
yes,
a
that
chance
would have
to.
been
My
an additional
lord, one
advantage.
point would be
Yes.
Your
Just
Lordship.
a moment.
My lord.
Were you one of the successful candidates in that original list?
I have to seek instruction. That instruction I need because I cannot make it.
Because if
But
you
what
were
I
not,
submit-
if you were not a successful candidate in that original list,
My lord.
then under such circumstances you cannot have added advantage at a later
No,
stage
nothing.
because
Because
you were
my
not
concern-
because you were not put under any disadvantageous position by virtue of the
My lord.
original selection process.
But what I am
My
trying,
lord,
two
one
questions, if
submission,
I,
Your
my
Lordship.
friend will, two submissions. It is not the file has unnecessarily got so much bulky. Two issues has to be addressed, in my understanding. One, whether they have to make the merit list for scheduled this limited examination separately and direct recruit
No,
separately
you
or not.
are not going to the root question. The root question is whether you were successful in the first place, because you had nothing to do with non-scheduling. Yes.
In my
My
humble
lord,
submission,
that has bearing, your lordship, because your lordship subject
That
to your
has a
lordship-
bearing.
That
Certainly it
has
has a
a
bearing.
bearing, your lordship, subject to your lordship's
Whether
pleasure.
your candidature was to be considered again.
My lord, because after passing the Soni Kumari order, read with your lordship order dated 15/12/2022, there is no scheduled district. Now all has to be operated on the basis of the state-wise merit list.
what I am trying to submit is that that will not have any material bearing, because Honorable Apex Court has said that after Soni Kumari, you have to prepare a merit list.
You see,
We-
the merit list has to be
We
prepared
prepare.
state-wise.
Yes.
Even for promotees, it has to be prepared state-wise.
State-wise, that is what I am saying, is whether they have prepared, what they have done, all
No,
direct.
no, we want to know whether you were a successful
I will
candidate
take
at the
instruction.
first place.
I will take
And whether your suppose you were not a successful candidate in the first place,
Yes, madam, then.
right?
Yes.
Then by virtue of state-wise merit list,
Yes.
if you get some footage, then under such circumstances, will you still insist on the on your reservation and on your preference of districts, etc.?
My lord, if what I am trying to submit, I am in total agreement what has fallen from my lord's side. My submission is that if in the state-wise merit list, I am thrown to 100th rank, I will go to Saraikela. But if I stand at 1, then the Supreme Honorable Apex Court has not said.
They have given you your position in the
No, he
state-wise
has not.
merit
Yes,
list.
they have never prepared this. That is why. Let them come forward whether they have prepared
That
for
is not
people.
under challenge.
See, he will
What
never
he
allow
has-
to conclude
we-
the things. He will
what
jump
he
in the
has
middle to
pleaded
create a
and what he
confusion.
is
My
arguing,
submission
that
is,
is different
it
to
was a
what-
duty to prepare two lists or not.
Our concern is whether you were successful in the first place or not.
I will respond on instruction.
And then only we'll also figure out.
Yes.
A person belonging to scheduled district, applying under scheduled district category for the same, right? Who had no disqualification under the existing advertisement. Whether his candidature is to be considered afresh.
That we will respond. My lord. On instruction, I will respond. Give us a week's time, I will respond. We will respond to that. But my larger issue is that what we can choose. This is what arbitrariness says, by that for Ranchi, I am a Ranchi based, I am thrown to Saraikela Kharsan. Everybody
So you
wants
are
to.
Ranchi based. So
And
you had full advantage in the first selection
First
process.
selection.
You had full advantage.
he has not said, I will
No,
respond.
naturally, because you will have to respond to this court's
Yes,
query
I-
whether you
I
were
will
successful
satisfy
in
my
the
lord on
because
each and
you were put under an advantageous position in the first place. When the original advertisement was issued, you
My
were
lord,
in a much advantageous
let-
position
let
because when the merit list is prepared state-wise and when it is prepared district-wise, it makes a lot of difference.
lots of difference.
Yes.
Huge difference.
So,
I will
so
respond
you,
to that.
you
This-
being at an advantageous position in terms of the original advertisement, having not been selected at the first instance, what right will accrue to you by virtue of the subsequent order?
And whether the receipt of promotional
No,
will
that
go
will
to
come
direct.
later. Firstly, you will whether you
Yes,
will be
sir.
whether
Yes,
you will
sir.
have any advantage or you will not have
I will
any
not
advantage
respond in
out of
ifs and
that.
buts, my lord. Let me have instruction from my clients. But that will be a larger issue, my lord, because there the state is playing smart by putting the choice
You
person.
are also playing smart.
No, ultimately it is not pleaded
Was,
against
was
me.
it not your duty to place it on record that in the first place you were ultimately selected or not selected? What was your position in the first place? Apparently you were not selected at the first instance.
No, I cannot say, my lord. Let me have
Because
instruction.
you have not said so.
Silence.
Suppose you were selected. There was no occasion for you to come to the court.
If I would have been selected, my lord.
Because the candidates who were already
Now,
selected,
page number 140.
the candidates who were already selected, their selection was saved by the Honorable Supreme Court. Isn't it?
The first list of 4 December 2018, which is at page 140, I am selected.
140.
Yes, my lord, my learned friend is making, he has not responded to that. NST 5, page 140. My lord will say.
Yes, where are you?
I am, my lord, just above Kuduk, that is Gumla Ranchi, last row, my lord will see P2, that is 28123239484. My lord has got it. Just above Gumla, there are 2 lines roll number, my lord.
Just above Gumla.
Yes.
What is your roll number?
There are 2 petitioners, my lord. For
Okay.
petitioner number 1, it is 281 6626
Give the last digit only.
41
41.
and 84
41
and 84
and
84.
84.
Yes.
Then you
Working
must
teacher.
have joined pursuant date.
My lord, that is not the
That's
selective,
what
that
they
is the
have.
document
Then this
verification list.
honorable court stayed it. Sir, या तो आप बोल लीजिए.
नहीं, you are,
This is creating. This is something.
that is not correct fact, my lord. That is not the
Have you
result.
denied it?
That is
Just
not the, that is
You
the-
are not stated, so he has not denied.
No, I have
Where is
annexure.
your statement in the writ petition? Annexure से मत बहस क्या करिए?
नहीं,
Because I am
नहीं,
time and again telling you all of you.
Paragraph J, page 15. My lord, मैं पेंडिंग है.
You tell us whether you were ultimately selected in the first round or not. Page?
15 of my petition, para J,
Yes.
that both the petitioners were declared successful in combined trained teachers examination and were called for counseling. The same is evident from the list of candidates called for counseling on 4 December 2018. Let him say where from counter affidavit.
No. Ultimately, the result was ultimately declared, and persons were allowed to join, as I understand.
No, it was not.
No, they were already working for 3 years.
So some of them had joined. Thereafter, there was a stay order by this honorable court.
Ultimately, do you want to say that this result of counseling was not declared?
I will
Do you
file
want
an
to-
affidavit to that effect. I cannot say what is not there in my petition.
Learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioners had applied under the reserved category
Of working teacher.
of
Working teacher.
working teachers, and a separate merit list was to be prepared for such teachers. The petitioner number 1 is a scheduled tribe
Tribe.
candidate belonging to district of Ranchi and had applied for the scheduled district of Ranchi.
No, my lord. Gumla. I had applied for Gumla. And I am resident of Gumla. I am mentioned in my petition. Let me be very clear, my lord. I cannot say, let me have instruction. I will furnish my detail of my residence, my application, everything I will furnish.
So you are a resident of Gumla.
Yes.
Initially you applied only for Gumla. So then why is your result being...
I applied for Ranchi, my lord. The judgment of apex court says that those who have applied, if contempt order may be seen, those who have applied for scheduled area will be considered for that. If contempt order that I have passed on, my lord. So let me be very clear.
You were declared selected in Gumla district only, not in Ranchi district. You were called for counseling in Gumla district, not in Ranchi district. See page 140?
Yes.
Then?
Let me file my affidavit. I will be very clear on this point. Let me file an affidavit.
अभी नौकरी हाथ में है, अभी क्या क्या करवाना चाह रहे हैं?
नहीं हम फाइल
बहुत समझ
करेंगे. My lord, as a citizen of this nation, my lord, I am before my lord for justice. हम क्या करवाएंगे? देखिए प्रेफरेंस दिया गया, that is not been shut down. मेरिट लिस्ट आज तक आप देखिए इतना 30 रिट पिटीशन फाइल्ड है आपके सामने because of the failure on the part of JSSC.
What he is saying, my lord, that has been heard by your lordship. That has been
addressing.
day
My lord,
before
where the
yesterday
citizen
was
will
heard.
be.
My lord,
If my right is not in accordance with the
Citizen will
evidence,
get
so मन में आया
everything
वो बोल
only
दिए.
if they come up with very clean hands.
Yes, I will file, my lord. I am saying
आप
that.
अपने ही इतना देर से बोले कि आप रांची के हैं, रांची के लिए
I
अप्लाई
will
किए
take my
हैं,
instruction.
आप
I
बोले
will
रांची
take-
के लिए हम सक्सेसफुल हो गए हैं, then that is not supported by your देखिए I'll tell you one thing.
Yes.
भैया हमारे यहाँ ना रिकॉर्ड बढ़िया से पढ़ के बैठते हैं.
Give me 1 minute.
Because
Just
our
my-
mind works accordingly we trust your statements.
Yes.
And then you take a U-turn. This particular annexure 5
Yes,
at
it is
page
for Gumla.
140, it is for Gumla.
Yes. I tender my vote.
Then
Let me file an affidavit, madam. Let me file an affidavit. It has to come from the client. Let me file an affidavit to that effect, disclosing my entire how I applied, from where I applied, when I was given the counseling notice, for which district I was given. This all detail I will bring.
petitioner number 1 is
Even the
ST
annexure 5 is
and
incomplete.
petitioner number 2
He had applied. He says EBC, but my petition says I have applied for general category. That is my petition says. And they say in their counter that it is EBC. If I refer to my petition, my lord, I have stated.
the learned counsel for the parties are present. The writ petition is not at all clear with regard to the candidature of each of the petitioners. and under what category they had applied and from which district. It is also not clear. And it appears from the writ petition that petitioner number 1 was called for counselling in the district of Gumla.
Both the petitioners,
Petitioners were called for counselling in the district of Gumla, but the final result of the selection process in the district of Gumla, prior to passing of the order by the Honorable Supreme Court, has not been brought on record. It is not clear as to whether the petitioners were declared successful while participating in counselling in the district of Gumla in their respective category. Gumla is a scheduled district.
yes.
Gumla is a scheduled district,
My lord,
and as per the writ petition, both the petitioners belong to the district of Gumla.
that this time we had stated.
However, they are insisting that they ought to have been given appointment in the district of Ranchi on the basis of their preference.
Separate merit list to be under working teacher.
On the basis of their preference. Right.
If having fallen in the category,
The foundational fact be brought on record by the petitioner by filing a supplementary affidavit. Let the supplementary affidavit be filed by with all supporting documents. Let the supplementary affidavit be filed by 24th April.
one more week when we are posted at Saraikela Kharsman.
आपको बेसिक फैक्ट देने में इतना परेशानी नहीं होना चाहिए.
एफिडेविट आगे करना होगा ना.
वीकेंड है बीच में. They have to come for this. ज्वाइन करने के बाद आप इतना कॉम्प्लिकेशंस में जाना चाहते हैं. I am absolutely clueless. Are you serving your clients or you are entering into such arena of dispute which will unnecessarily, which may, I don't know,
Well, we are
which
before
may
my lord.
no,
We
certainly.
folded and we are before my lord. If we
The-
are having a right, then my lord we expect a justice. That is,
No,
we can make out a case.
I am also conscious of the fact that if it comes that you were successful in Gumla or whatever, we do not know, you were unsuccessful in Gumla, applying in the scheduled district, belonging to the scheduled district, having become unsuccessful, what kind of right will flow to you is something which is.
We'll try to satisfy them. Ultimately, my lord, as a lawyer, we can assist and we cannot come to a conclusion before filing a writ petition. We are always trying to evolve and interpret the things to
Anyways,
the best possible manner.
you file it by 24th.
But I was still
Post on-
requesting my lord every more time, my lord, because there is certain personal
No,
engagement.
we have spent so much of adjournments, so much of time in this record, and foundational facts are not clear from the records of this case. Every time we have to read these briefs, right? Post on 25th in the supplementary copies.
My lord, on 25th your office there is full.
आने दीजिए ना इनका एफिडेविट पहले.
That is हमारा
I will
अगर
submit
इनका
to you.
सैटिस्फैक्ट्री एफिडेविट आएगा तब आपको रिस्पॉन्ड करने बोलेंगे ना. एफिडेविट में ही कुछ नहीं है तो क्या रिस्पॉन्ड करने बोलेंगे. Then I will narrate their entire arguments. You can prepare a short note, point wise, 1 page. I will narrate it in my order, and then I will ask him to respond.
If it is on 26th your office, because I will 10:30 बजे
आपको कोई जरूरत ही नहीं
26 मेरे
है.
लिए भी my lord there
Let
is
him let his affidavit be there. Let your
date
email be
26
there.
को date 26 को लगा my lord, because I am also having personal difficulty.
26 को नहीं हो सकता. 26 is a Friday ना. it is
Friday.
difficult.
Personally, I am having that.
ठीक है,
Because now
26 को कर दीजिए.
ongoing this election processes are there.
On 26th in the supplementary cost list.
Under heading for fresh filing, item 5 WPS 670 of 2023.
May I please? The petitioner has challenged the letter number 239, page number 16, annexure 4, by which the she has been removed from the Anganwadi Sahayika member. It is stated in the letter note कि work is not satisfactory, उनका लापरवाही था. So cause issues, so cause she has given the reply to so cause not, but same has not been accepted. She has represented to the Deputy Commissioner Kodarma and the representation is pending for the Deputy Commissioner.
Let him consider it. Learned counsel for the parties are present. The state petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the
Representation action 5 page number 17.
just a minute.
That is pending.
The learned counsel for the petitioner has submitted that the petitioner has filed his representation before the deputy commissioner as contained in annexure 5 to the writ petition and the same is pending. The learned counsel appearing on behalf of the respondents has also referred to paragraph 15 of the counter affidavit to submit that the representation dated 19/12/2022 has been filed before the Deputy Commissioner Kodarma, but the petitioner lost her patience and has approached this court without waiting for the outcome of the same. This counsel for the petitioner has submitted that appropriate order be passed so that the representation of the petitioner can be taken to a logical end. After hearing the learned counsel for the parties and considering the aforesaid submission, this court finds that the petitioner has already raised her grievance before the Deputy Commissioner Kodarma, white representation dated 19/12/2022 and filed the writ petition before this court on 2/2/2023. Since her representation is pending, this court is not inclined to enter into the minutes of the case. The Deputy Commissioner Kodarma is directed to look into the grievance of the petitioner and pass an appropriate order after granting an opportunity of hearing to the petitioner. The needful be done within a period of 1 week from the date of receipt of a copy of this order, along with a copy of the writ records. The state petition is accordingly dismissed. The reason order be communicated to the petitioner through speed post.
From the daily list under heading for orders, item 10, criminal revision 29 of 2019.
Who's for the petitioner? Password. Are you there? Are you there in this case?
Item 10.
Item 10? 13. Please the password.
Item 11, criminal revision 96 of 2019.
इनको नाम फ्लैश करिए. Yes, petitioner. Criminal Revision 96 of 2019. Nobody appears for the petitioner. However, time till May 24 is granted to the petitioner to remove the surviving defects preemptively. If the defects are not removed within the stipulated time, the order of dismissal be drawn and be immediately communicated to the court concerned through fax/email. Immediately drawn within a period of 3 days thereafter. If the defects are removed, post this case under appropriate heading on 16th of May.
Item 12, Criminal Revision 106 of 2019.
Yes, petitioner.
No, this revision is not maintainable in light of judgment passed in Joseph Stephen and others versus Anganwadi and others.
आने दीजिए petitioner को उनके प्रेजेंस में ऑर्डर करना पास ओवर कर लें ऐसे मेजोरिटी पर बहुत सारे केसेस जस्ट वेट फॉर सम टाइम
Item 13, Criminal Revision 170 of 2019.
Like give for 1 week time to file an application for convert this revision application into the appeal.
No, you can file it fresh.
My lord,
Conversion नहीं करेंगे.
I will file your lordship may pass any order, but I have to file because I have filed this revision application 2019.
No, I will record everything.
No, my lord,
सारा
I
date,
know. I
certified
have
copy,
seen your
certified
lordship
copy भी
order.
हम आपको दे
I have
देंगे.
seen, yes, my lord. But a lady, my lord, who is not receiving a single maintenance, will file again an application.
Maintenance?
नहीं, maintenance का ये case नहीं है, but is a case is acquittal by
अगर
the
उनको दिक्कत है तो आप हम लीगल एड प्रोवाइड कर देंगे. हम अपना
लीगल एड 5 साल के बाद में एक बार टेकअप हो रहा है, एक बार नोटिस इश्यू हुआ है. हम कई बार मेंशन आई हैव मेंशन सेवरल टाइम.
तो आपको केयरफुल रहना चाहिए ना मेंटेनेबल होगा कि
मेंटेनेबल 2019 it was maintainable because in
2019 से आप क्या कर रहे हैं इसको?
judgment has come for non maintainability 2022.
Just a moment.
Yes.
आपका तो ये थ्रू आउट डिफेक्टिव रहा है.
No defect. It was सिर्फ एक फाइल करना था हमको. आईए भी हम फाइल कर दी, इसलिए डिफेक्ट में दिखा रहा है वो कि हम आईए फाइल लिमिटेशन के लिए फाइल था, इसीलिए डिफेक्टिव दिखा रहा है. It was not. और ये जजमेंट 2019 में टुकलाल यादव का आया था, उसमें ये रिवीजन होता. लेकिन 2022 में जब स्टीफन्स ऑनरेबल सुप्रीम कोर्ट से जजमेंट ऑफ स्टीफन्स आ गया तो ये अपील हो गया. But when I was filed, it was correctly filed and no defect was also pointed, no objection was raised. And therefore, in the Stephens case also, the liberty was High Court was directed to convert the same into the revision in view of the since it was filed in a wrongness. And that noting has been given in the Joseph Stephens case. In last line, it has been given.
Not in all the cases.
In all, that is why I make out a ground that it is a wrong notion. It is I have filed it due to wrong notion, and then it is not in my fault. Then this court has power to.
Criminal Revision 170 of 2019. Counsel for the parties are present. Counsel for the petitioner submits that the present revision is not maintainable, but he prays for time to file an appropriate petition to convert it into an appeal.
Yes.
देखिए अपील में बहुत प्रॉब्लम है. I'll tell you one thing. किस प्रोविजन में अपील फाइल होगा उसमें भी बहुत कंफ्यूजन है. Therefore I will not. I don't want to decide that issue because आप मेरी बात समझिए. सिंगल जज बैठ के ये कैसे डिसाइड कर देगा ये अपील हम किस प्रोविजन में एंटरटेन करें?
नहीं, ये डिसाइड नहीं करना. इट विल कन्वर्ट अपील देन इट इज द स्टाम्प रिपोर्ट विल बी डन. देन
अपील का प्रोविजन बताएंगे ना आप?
हम 372 प्रोविजन में फाइल करेंगे ना.
इतना सिंपल मत समझिए आप हर चीज.
कंफ्यूजन है तो सच कंफ्यूजन. सेम जजमेंट है.
आइए फाइल करेंगे तो हम भेज देंगे डीबी में, वहीं पे जाके करेंगे.
हम आई फाइल.
The counsel for the petitioner submits that he shall file appropriate IA within a week. एक हफ्ता में फाइल कर दीजिए. Post this case on next Friday. No further time will be granted for doing the need.
Yes.
Next Thursday.
Next Thursday I will file by tomorrow.
In serial number 11.
Is it the mentioning time? So please have your patience.
Item 14, Criminal Revision 520 of 2019.
Yes, also pray for the time on behalf of the petitioner.
I'll kindly see the last order in this case. Order dated 22nd.
This is not maintainable. We are not going to entertain this. We will not. This is not maintainable. You can file your appropriate petition. It is covered by the judgment of
Joseph Stephen.
Joseph, and we have also passed an order.
Yes.
कौन सा है? बताइए जरा.
Joseph Stephen.
नहीं 16611.
2020.
इनको दिखा दीजिए. दिखाइए आपको. अरे कोई आपका डिसमिस थोड़े कर रहे हैं. उनको दीजिए. पिटिशनर को दीजिए.
Conducting a revolt is a small solution on behalf of conducting a revolt.
By way of last indulgence, a time was granted.
It is out of station है.
कुछ नहीं, और सब कहानी मतलब बस.
बस ये वो.
देखिए, criminal revision number 520 of 2019. Counsel for the parties are present. The counsel for the order dated 22/3/2024 is quoted as under. Counsel, the perusal of the records of this case indicate that the petitioner before this court is the informant of the case, which was numbered as GR 3548 of 2012, arising out of Parsudi PS case number 309 of 2012. The opposite party, the accused was convicted, and the appellate court in criminal appeal number 121 of 2017 has passed an order of acquittal and has set aside the impugned and has set aside the judgment of conviction and sentence. It is submitted that in view of the judgment passed in the case of Joseph Stephens versus Sanatsami, reported in 2022, 13 SCC 115, decided on 25/1/2022, the present appeal, the present revision is not maintainable. The Honorable Supreme Court in the case of Joseph Stephen Supra yes. Similar view has been taken by this court. By considering the case of Joseph Stephen and others, and also the full bench judgment of this court in the case of Tukalal Yadav. नहीं ऐसा लिखिए इसको, वो टुकलाल यादव का रेफरेंस अभी इसमें मत दीजिए. पैराग्राफ 23 से ले लीजिए इस जजमेंट का. क्रिमिनल रिविजन नंबर 661 ऑफ 2022. पैरा 23. Then 24. Para 25. In view of the aforesaid judgment passed by the Honorable Supreme Court in the case of Joseph Stephens, this court is of the view that the present revision is not maintainable. Accordingly, this revision is dismissed as not maintainable. However, liberty is reserved with the petitioner to take appropriate steps in accordance with law. Upon being approached by the petitioner, the office is directed to return the certified copies of the judgments passed by the concerned court in these proceedings, being replaced by true copy / photocopy of the said judgment. आपको मिल जाएगा सर्टिफाइड कॉपी, आप फ्रेश अपना पाइए.
Limitation will come out.
आपका सारा अच्छा लाइए नीचे से. ये जो है ना आपको मिल जाएगा सर्टिफाइड कॉपी, इसमें सारा डेट्स होगा, ठीक है. द impugned appellate order is dated 11th December 2018 and it was filed before this court on 24/4/2019 and as per the stamp report there was delay of 39 days. Delay था इसमें.
Limitation condoned.
And the limitation was condoned by this court in IA number 2829 of 2020 by the order dated 29/11/2022, and thereafter this matter has remained pending. The counsel for the opposite party number 2 has also entered appearance pursuant to notices issued by this court. Right?
Item 15, Criminal Revision 449 of 2020.
Yes, Your in this case, petitioner has surrendered and they were convicted in lordships under section 25(1)(ba) and 35 and 26(2) and 35 of the Arms Act lordships. And the maximum sentence is 3 years.
There are certain defects also. Defects are continuing.
So under admission is for fresh filing.
Fresh filing में.
Waiting for admission.
Orders में है लेकिन डिफेक्ट एग्जिस्ट कर रहा है.
डिफेक्ट एग्जिस्ट कर रहा है. देखिए जरा क्या डिफेक्ट है. इग्नोर करने लायक हो तो करेंगे. फिर दिखाइए. ऑर्डर्स में है तो देखना चाहिए ना डिफेक्टिव है.
Item 16, Criminal Revision 783 of 2020.
filed for delay.
अरे वो 661 वाला ऑर्डर उस फाइल में चला गया, उसको निकाल के दो. Yes.
In this case, Your Worship, there is delay in preferring the instant revision application. Delay is of 209 days.
$209.
Your Worship.
Notice has been issued. Notice has been issued.
This is
FIR or complaint?
FIR, Your Worship.
There is a petition for condemnation.
IA number 3211 of 24.
Learned counsel for the petitioner is present. Nobody appears on behalf of the state. IA number 3211 of 2024 has been filed seeking condonation of delay of 209 days in filing the present revision. The counsel for the petition has submitted that due to adequate means, the petitioner was not able to prefer the revision application. After going through the petition for condonation of delay and being satisfied with the cause shown, IA number 3211 of 2024 is hereby allowed. You are in custody?
Your Worship, report may be called for it is through Chancellor letter, and I had been handed over to, and appeared through only memo of appearance. I think that he might have been served the entire sentence.
Custody statement is missing. वकालतनामा कहाँ से आया?
I am simply appearing through
कारपाल.
Your Worship, memo of
कितना
appearance. I
देर?
had not even filed
That's right.
वकालतनामा also.
कितना का सजा मिला?
2 years, Your Worship,
2 years. Okay.
under arms.
Counsel for the petitioner has submitted that the petitioner has been convicted only for a period of 2 years.
Yes.
A report may be called for as to whether the petitioner has served the sentence. Let a report be called for from the concerned court regarding the custody of the petitioner in connection with the present case, clearly stating as to whether the petitioner has served the sentence. फिर भी आप करेंगे तो है ही, जब आपके पास आया है तो,
Your Worship,
है ना? करना तो पड़ेगा ही.
जी बिल्कुल.
Let a copy of the records. जरूरत पड़ेगा records का.
मैं डाल दिया.
Office is also आ गया
NCR is
है.
there.
Okay. इसी से तो पता चल जाएगा, नहीं पता चलेगा क्या?
इसमें तो जो तक का ही
You see, this impugned order was passed on 27/9/18.
Yes, but at that time here, at the time of disposal of appeal, it is not necessary that the accused is taken into custody at that point of time only.
That's let pose this case on 9th of May, awaiting the report from the court concerned. Under orders रहेगा.
Your Worships, there is defect of court fee, Your Worship, rupees 260, Your Worship. Your Worship, I can file it just
Please
now.
file it and come.
And Your Worship, one more
You
defect
have
is.
filed any petition for suspension of sentence?
No, Your Worship, that has not been filed, Your Worship. It was paid. Prayer was made in the revision
अलग से
itself,
petition
Your
file
Worship.
करना होता है ना?
Yes, Your Worship, हम एक prayer करते हैं, Your Worship. One more defect is there. After conviction and sentence, Your Worship, during trial के वक्त जो हम लोग VA move करते हैं, वो हम लोग ना तो अपील ना तो रिविजन में लिखते थे, Your Worship, पहले. तो ये 20 का फाइलिंग है, Your Worship. तो उस वक्त पहले
नहीं।
एक ही तो ये राशि मेंशन कर देंगे वो
नहीं, आप नहीं ऐसे मेंशन कर सकते इसका
नहीं
क्या
मेंशन ये राशि हम आईए में मेंशन कर दें
कल
तो
रख दो।
चल जाएगा राशि यार सेपरेट सप्लीमेंट्री इज रिक्वायर्ड
Supplementary is
सप्लीमेंट्री एफिडेविट इज
कल
रिक्वायर्ड ठीक है राशि
लेकिन
सप्लीमेंट्री
कल करने से नहीं होगा ना, आपको आईए फाइल करना पड़ेगा for
आईए
suspension of
राशि आईए
sentence.
फॉर सेपरेट प्रेयर
Counsel for the petitioner prays for adjournment post on next Thursday. In the meantime, the petitioner shall remove the surviving defects.
a simple defect is there एक राशि का करेक्शन कर दे
आप
राशि
सब कर दीजिए, आप
अभी-
अभी तुरंत कर सकते हैं, whatever you want to.
एक करेक्शन है बस राशि इनेक्शन नंबर
जो हाथ से करना है कर लीजिए, जो फाइल करना है कर लीजिए, सस्पेंशन ऑफ सेंटेंस फाइल करना है वो भी कर लीजिए.
Item 17, criminal revision 626 of 2021.
Resolution, my lord, under section 498 is only against the husband, my lord. The High Court convicted the father-in-law, mother-in-law, and husband.
तो जॉइंट कॉम्प्रोमाइज फाइल हुआ है.
And joint compromise filed here, my lord.
Where is the informant?
She has come, my lord.
Where is she?
She has come.
बुलाइए भाई, काउंसिल को बुलाइए.
हम बुला लेते हैं. Yes.
जॉइंट कॉम्प्रोमाइज में क्या बोले हैं आप?
बहुत सारे लिविंग टुगेदर, my lord. Matrimonial relation has been restored between the wife and husband, so that they have compromised the case. So one IA also filed for joint compromise, my lord, and one IA for exemption from surrender, only to the husband.
कहाँ है, बुलाइए.
हम बुला लेंगे.
देखिए, एग्जेम्पशन फ्रॉम सरेंडर हम अलाउ कर देंगे. जॉइंट कॉम्प्रोमाइज हम आराम से 1 साल बाद सुनेंगे जब शांति रहे, ऐसे नहीं. राइट, जब दोनों शांति से 1 साल तक रहेंगे उसके बाद जॉइंट कॉम्प्रोमाइज सुनेंगे. एग्जेम्पशन फ्रॉम सरेंडर हम अलाउ कर देंगे. फेयर एनफ.
Madam,
बुलाइए,
I am calling.
काउंसिल को बुलाइए.
हाँ बुला लेंगे.
मियाँ बीवी के जॉइंट कॉम्प्रोमाइज को थोड़ा दिन पेंडिंग रखना चाहिए, है नहीं मैडम? थोड़ा दिन पेंडिंग रखना चाहिए. Let them settle in life.
Watch the conduct.
Item 18, WPL.
My lord, in this case, my lord,
Yes.
in this case, my lord,
Item 18.
some more time may be granted to file supplementary affidavit because the some of the workmen has died, my lord. I have received instruction, my lord, from the my client, my lord. So I filed supplementary affidavit, my lord, giving the name of those workmen who died, my lord. 27 workmen have died, my lord. I have received instruction, so some time may be granted to file.
WPL, they are seeking adjournment that some have died. कितना, 1 हफ्ता बहुत है, अब तो आपको
No, no,
इन्फॉर्मेशन मिल गया.
मिल गया है, फिर करने के लिए तो बीमार है, 2 हफ्ता कर सकते हैं.
WPL number 1762 of 2022. Learned counsel for the parties are present. The counsel for the petitioner prays for and is granted time till 2nd of May 2024 to comply the order dated 12th of March 2024. He has also submitted that 27 workmen have expired as per his information.
नंबर तो उतना भेजा वो गिने नहीं.
About 20
हाँ
About 27 workmen who are involved in the present case have expired. During the pendency of this case,
We have given the name by way of supplementary.
post on 3rd of May 24 in the supplementary cause list under the heading for orders.
Item 19, criminal NP 1511 of 2023.
Yes, ma'am.
SC ने फाइंड सप्लीमेंट्री और सारे एक्सपेंसेस जो भी खर्च है मैंने उसमें मैच किया तो उसका इंटरेस्ट अमाउंट उसके मेंटेन करने
ऐसे नहीं हो सकता. There is no surviving grievance. Then it comes for the petitioner submits that she does not have any surviving grievance, and accordingly counsel name the petitioner in person submits that she does not have any surviving grievance, and therefore she does not want to press this surviving grievance as on date, right? Therefore she does not want to press this petition. Accordingly, CRNP number 1511 of 23 is dismissed as not pressed. Right? Sign correct. Put your signature. Yes, madam, you have to put your signature.
Under heading for fresh filing, item 20, criminal revision 749 of 2021.
दूसरा कोर्ट में भी ऐसे ही बीच में बोल देते हैं. ये सिर्फ इसी कोर्ट. Yes.
So, the petitioner is agreed by order dated 7/8/2021, Your Lordship, which is at page Your Lordship's page, start from page 42. Your
Where is OP number 2 in this case? Serve हो गया उनको? समीट या छुट्टी को?
Yes.
अच्छा. चलो क्या प्रयास करना है? एक किस हेडिंग में है ये मैटर?
Fresh filing.
Fresh filing.
यस, व्हाट डू यू हैव टू ऐड?
Your Lordship, the petitioner is agreed by order dated Your Lordship 7/8/2021, Your Lordship, and starts at page 42, whereby her protest application has been dismissed, Your Lordship. Although she has filed a case, Your Lordship.
Can you read it? Can you read the
Order, Your Lordship. A petition filed on behalf of the informant Pratibha Kumari by serving the copy of the learned APP, which put up for hearing her the learned counsel for the informant and the learned APP and perused the APP petition of the petitioner. It is submitted therein the petition that the case has not been registered under all the required sections of the different acts and the investigating agency has not properly investigated the case. So protest may be appropriated, and by cancelling and passing the final report dated 18/12 submitted in the present charge Mahila PS case number 22 of 2020, the cognizance against the accused persons may be taken under section 120B, 153, 186, 307 and all the relevant sections you also mentioned therein. IPC and 217, 19, 8 of DB Act and 234 of DP Act, 2 of Human Rights Act and other relevant acts of the Constitution of India by exercising the judicial power vested with the court under the relevant provisions of the Act, and the accused persons may be summoned for facing trial and they be tried, prosecuted and punished in accordance with law. It is further allegation of the informant that she is aggrieved with the grant of anticipatory bail petition of all the accused persons by the learned sessions of Bukhara and APP number so on 1/8/2021, and the accused persons have abused the liberty of bail granted by the sessions court, so the bail of the accused person may be cancelled. Now, it is evident from the perusal of the record and the order sheets that cognizance order has already been passed by in this court on past in Nikis on submission of the charge sheet by the investigating agency, and this court has got no jurisdiction to review its order. Also, the prayer of the petitioner for quashing comes under the purview of the power conferred upon this court. This court has also not got any jurisdiction to debate the merit or the merit considered by the court of sessions during granting the alleged anticipatory bail to the accused person. Thus, this court has not cancelled bail of any accused which has been granted by the court of session and
Yes,
not by.
then once cognizance has already been taken on whatever sections, then you have to challenge the order of cognizance or do whatever with the order of cognizance. Now you cannot pass and file a protest petition and then now have a different case also. It is not a case of final form submitted. It is a case where cognizance has been taken under some of the sections. So there is no
after final form, after charge sheet has been submitted, cognizance will be
cognizance. So therefore, this is not maintainable.
taken. My lord, may pass.
Learned counsel for the petitioner is present. This petition has been filed with the following relief. Learned counsel for the petitioner submits that the protest petition has been wrongly rejected by the learned court. After hearing the counsel for the petitioner and upon going through the impugned order dated 7/8/2021, this court finds that a petition was filed on behalf of the informant, who is a petitioner before this court, by alleging that the case was not registered under all the required sections and the investigating agency did not properly investigate the case. And various sections were mentioned in the petition in which the cognizance and various sections were mentioned in the petition, and it was argued that by exercising judicial power, the accused may be summoned to face the trial under the sections which were mentioned in the protest petition. A prayer was also made with regard to cancellation of anticipatory bail granted to the accused by the learned sessions judge in ABP number 1245 of 2020. The learned court has rejected the said prayers on the ground that upon submission of charge sheet, cognizance was already taken on 5/3/2021 and the court had no jurisdiction to review its earlier order. And so far as anticipatory bail is concerned, the court observed that the court had no jurisdiction to cancel the anticipatory bail granted by the learned court of sessions. The learned court rejected the petition as not maintainable. After having gone through the impugned order, this court finds no illegality or perversity, calling for any interference in the impugned order in the division jurisdiction. Accordingly, this revision is hereby dismissed. इसका लास्ट पैरा को कोट कर दीजिएगा impugned order. आगे? कहाँ है?
Item 17.
Where is the husband? Husband has also come.
No, husband.
Husband and wife was Bombay.
Wife.
Wife I have तो husband का चाची आई है.
चाची भी accused है.
नहीं accused नहीं. फादर बहुत सीरियस है तो नहीं आ पाए इनको भेजिए.
आप वाइफ हैं?
ये वाला.
पिंक वाली है ना? और येलो जो है
ये उनका फादर भी
आपकी सास है? चचिया सास?
चाचा.
अब अच्छे से रह रहे हैं आप लोग?
हाँ ठीक.
इस केस को कुछ दिन पेंडिंग रखें कि खत्म कर दें केस? कर दें? अच्छे से रहिएगा? तो डाउट नहीं ना है मन में? ध्यान रख रहे हैं आपका? आपका क्या नाम है? नाम बताइए. सीमा. ये आपके वकील साहब हैं? चलिए. देखिए क्रिमिनल रिविजन नंबर 626 of 2021. The learned counsel for the state कहाँ है? स्टेट से तो पूछ के करना होगा ना. The learned counsel for the petitioner and opposite party number 2 are present. This revision has been filed against the order dated 24/6/2020 passed by learned Additional Sessions Judge Roman 3 Rajmahan, whereby the appeal filed by the petitioner has been dismissed. The petitioner has been convicted by judgment dated 21/12/2019 passed by learned Judicial Magistrate First Class Rajmahan in TR number 245 of 2019. For offence under section 498 capital A of Indian Penal Code and sentenced to undergo simple imprisonment of 3 years for offence under section 498A and also pay a fine of ₹1,000 for the same offence. The case was arising out of GR case number 658 of 2013. Criminal Appeal 4 of 2020. This is the order of the There are other accused persons also.
Also, they have been acquitted by the appellate court. Father-in-law, mother-in-law acquitted by the appellate.
From the perusal of the impugned orders, it appears that altogether 3 persons were convicted for offence under section 498A/34 of Indian Penal Code, and father-in-law and mother-in-law, that is father-in-law and mother-in-law of the petitioner of the informant were acquitted by the appellate court, and the conviction of the husband was sustained, and therefore the husband has filed a present revision application. The learned counsel for the petitioner has submitted that 2 interlocutory applications have been filed in the present case. One is IA number 3356 of 2024 seeking exemption from surrender, and the other is joint compromise petition contained in IA number 3355 of 2024. The learned counsel for the parties have referred to the joint compromise petition and have submitted that with the intervention of near relatives and friends, petitioner and the informant have settled their dispute, and now they are leading their conjugal life as husband and wife. They jointly submitted that the matter relates to matrimonial dispute and both having settled in order to secure the ends of justice, the impugned orders of conviction and sentence be set aside, so that the petitioner and the opposite party number 2 may live in peace. After hearing the counsel for the parties and considering the facts and circumstances of this case, it appears that the case was instituted arising out of matrimonial dispute, and ultimately the petitioner, who is the husband, has been convicted under section 498 capital A of Indian Penal Code, and other accused persons have been acquitted by the learned appellate. In view of the averments made in the joint compromise petition and the fact that the petitioner and opposite party number 2 have settled their dispute and are living as husband and wife, this court is of the considered view that, and they have also submitted, and it has also been submitted in the joint compromise petition for setting aside the judgment of conviction. This court is of the considered view that ends of justice would be served if the judgment of conviction of the petitioner is set aside. Counsel for the state has no serious objection in view of the fact that the petitioner and opposite party number 2 have started living as husband and wife. Accordingly, IA number 3355 of 2024 is hereby allowed. Both the orders, the trial court order as well as the appellate court order of conviction of the petitioner for offence under section 498 capital A is hereby set aside. As the judgment of conviction of the petitioner has been set aside, there is no need to surrender. Accordingly, IA number 3356 of 2024 is closed. Let this order be communicated to the court concerned.
Item 21 WPS 2294 of 2023. First.
Yes.
Matter relates to the regulation of the service of the petitioner for the post of driver, who is working since 1998 for more than 35 years on daily basis. Working on his sanctioned post.
Your case has not been considered.
Not
You have filed any representation.
Your lordship, dependency pending lordship.
Where is your representation? There was already an order. Annexure 6. What is Annexure 6?
Earlier petitioner moved.
So what happened?
It was rejected.
You can raise an industrial dispute. That was the observation of the court, isn't it? You read this?
Yes.
Annexure 6, page 22. Can you read? Read it, please.
One Constable the petitioner has submitted the petitioner is seeking regulation of his service as he has been serving as a driver since long from the year 1988 and is not regularized by the respondent. The present petition has been prepared. Having heard the learned counsel for the petitioner and looking the fact and circumstance of the case, it appears that petitioner seek relief for regulation on the ground that he has been serving as a driver since 1988. Petitioner can raise industrial
How can now you make the same prayer?
He has
Raise your
worked,
industrial dispute.
he has worked more
With
than
whom
30
were you?
years.
Maybe we do not know on the face of this order that it requires evidence and adjudication. What can be done about it? We can't do anything about it. Why didn't you raise a dispute? 2009 there was a observation.
They
We
have
will not
respondent
grant.
have admitted that petitioner is working for more than 30 years.
Admitted means?
The respondent have admitted that this petitioner is working for more than 30 years.
Where is the admission?
Sure. Page 21.
On the face of this order, it is very difficult for us to give you any relief, isn't it?
Page 20, 21. श्री विनोद राम साहू 1988 से दैनिक भत्ता पर कार्य
2012 का डॉक्यूमेंट अभी भी काम कर रहे हैं
ये स्टिल
वी डू नॉट वी कांट डू एनीथिंग देखिए आपके अगेंस्ट में एक ऑर्डर है उसको हम रिव्यू नहीं कर सकते ठीक है वी कांट
जजमेंट प्रोसीड नरेंद्र कुमार
उससे क्या मतलब है इट सेज दैट इट रिक्वायर्स एविडेंस this order is saying that it requires evidence and therefore you have been asked to go to industry tribunal. That order has become final against you. We can't do anything.
Page 20, 21 says that they have admitted that petitioner is working.
2012 में.
हाँ, अभी भी still working.
We do not. आप बात नहीं समझ रहे. क्या कर सकते हैं इनको तो कुछ कर नहीं सकते हैं. देखिए WPS number 2294 of 2023. Counsel for the parties are present. This petition has been filed for the following relief. From the perusal of the records of this case, it appears that the petitioner had moved this court in WPS number 176 of 2009, seeking regularization of his services by stating that he has been serving as driver since long, that is from the year 1988. But the relief was declined by this court on the ground that the petitioner can raise an industrial dispute under Section 10 of the Industrial Disputes Act for regularization. As it was also observed that it requires cogent and convincing evidence to be taken before the concerned court. And this court was of the view that in view of the decision rendered by the Honorable Supreme Court in the case of State of Karnataka versus Uma Devi as reported in bracket 2006 bracket close 4 SCC 1, the petitioner is not entitled for regularization. Order dated 6 April 2010 is quoted as under. In view of the order passed by this court in WPS number 176 of 2009, fresh writ petition for the same relief is not maintainable, and accordingly this court is not inclined to grant the relief as prayed for by the petitioner in this petition. However, if the petitioner still has a cause of action, if the cause of action of the petitioner is still continuing, he may avail his remedy in terms of the order dated 6th of April 2010 passed in WPS number 176 of 2009. Disposed of the district petition is accordingly disposed of.
In this case, may not pray for 215.
Pass over it. Pass over.
Passover case item 10, criminal division 29 of 2019.
Criminal division number 29 of 2019. Nobody appears on behalf of the petitioner. On behalf of the parties on repeated call. On 12th April 2024, the following order was passed. the revision has been filed. Nay, the petitioner is the complainant. In CP case number 1519 of 2014 corresponding to TR number 280 of 2018. This was instituted for offence under section 138 of Negotiable Instruments Act. The opposite party number 2 was convicted for the offence, and the learned was convicted for the offence by learned Judicial Magistrate First Class Dhanbad in CP case number 1519 of 2014/TR number 280 of 2018, and was sentenced to simple imprisonment for 3 months and fine of rupees 4,20,000. The Appellate Court of Sessions Judge Dhanbad, by judgment dated 26 September 2018, acquitted the convict allowed the criminal appeal and passed an order of acquittal, against which the present criminal revision has been filed. In view of the judgment passed by Honorable Supreme Court in Joseph Stephen and others versus Sanatan Swami and others, reported in 2020, Live Law SC 83. And also judgment passed by this court in criminal revision number 661 of 2020. आप हैं इसमें?
No, I am on behalf of the responding in question.
It is not maintainable?
No.
You have seen 661 of 2022?
Yes, yes.
The present revision is not maintainable. इनका appearance record करिएगा, Madam Majumdar का on behalf of opposite party number 2. Are you for the state?
Yes.
The learned counsel for the state, Mr. Pankaj Kumar, is also present. Okay. Petitioner is absent. The counsel for the state as well as opposite party number 2 have submitted that the present revision is not maintained. उसी terms में चला जाएगा 661 of 2022. इसके साथ 661 of 2022 का सॉफ्ट कॉपी लगा देंगे वर्ड डॉक्यूमेंट.
Item 12, Criminal Revision 106 of 2019.
Who is for the petitioner?
This is new division against the order of acquittal law.
It's not maintainable. You have a remedy under 370.
As per the judgment of Supreme Court.
Supreme Court and as per our court also, single judge में लिखा है. FIR case में लिखा है सर.
401 law that is 19.
नहीं, आप सुप्रीम कोर्ट का जजमेंट पढ़े हैं कि नहीं? ये acquittal appeal number 144 of 2019, which was arising out of FIR, there also it has been held that acquittal appeal will be maintained. Where appeal is maintainable, revision will is not maintainable.
Once the appeal has been moved in district.
आप कॉमन सेंस से मत बहस करिए भाई, थोड़ा जजमेंट पढ़ के नहीं बहस करते हैं तो गलत बात है. नहीं, टाइम तो हम बहुत दे चुके हैं, अब कोई टाइम का कोई स्कोप नहीं है. आप ये वाला ऑर्डर पढ़ लीजिए जोसेफ स्टीफेंस पढ़ लीजिए, सेकेंड हाफ में आ जाइए, उसके बियॉन्ड नहीं टाइम देंगे, नहीं आइएगा तो हम लोग ऑर्डर तो पास कर ही देंगे, ठीक है।
At the
लास्ट टाइम तो ऑर्डर डिक्टेट करके टाइम दिए थे, ऑर्डर नहीं पढ़े होंगे आप लास्ट टाइम। इनको जरा ये एक्यूटल अपील नंबर 144 ऑफ 2019 नोट करिए, मेमोरी इतना बढ़िया नहीं, लिखा हुआ है ना, हाँ तो देख कर आइए सर, 2:15 बजे आ जाइए, फर्स्ट केस टेकअप करेंगे।
Item 22, WPS 4096 of 2023.
क्या है ये?
Question of the reason order.
वॉशिंग ऑफ रीजन ऑर्डर,
Medical bill का
215 में तो हम लोग कुछ मैटर्स रखे हुए हैं, हम लोग का दूसरा बेंच। क्या हो गया था आपको?
हम एक्सीडेंट हो गया था, तबीयत खराब हो गई थी मेरी, तो फिर हम एडमिट हुए दुर्गापुर, फिर हमको पावन में ये कर दिया गया, फिर हम घर आए तो मेरी तबीयत ज़्यादा खराब हो गई, तो हम बिना रेफरल के अब चले गए।
BCCL case, there's a medical attendance rules which prescribe that if you first present yourself to the doctor of the BCCL, if he thinks that you are serious, he will refer you. It is clear that he was referred to another hospital. He on his own went to CMC Vellore. We have not received any information from CMC Vellore that he was admitted in a critical or emergency case. We have filed a counter action lawsuit.
He is asking for second half. He is asking for second half.
My lord had already said 250. I was just, my lord had already passed.
215.
Yes, yes, I will come.
Item 23, WPS 6627 of 2023.
Because challenge is to annexure 17 was part of the direction issued by the Millers in relation to whereby Millers Vaicharik or the retrospective promotion Millers has been denied Millers. Millers page 135 clause 4 is in code. Page 135 I am inviting Millers. Clause 4 Millers. Clause 1.
135.
Clause 4 Millers. I am agreed
Clause
by
4.
this.
Yes.
ग्रेड 4 एवं ग्रेड 7 के पदों पर कोई भी वैचारिक प्रोन्नति दे नहीं होगी। यह पद प्रोन्नति का है जिसका आर्थिक लाभ पद पर योगदान की तिथि से दे होगी। That's why I am agreed of Millers, because the 1993 rules are there Millers in relation to promotion of the teachers Millers. There are different grades of teachers Millers. Two are promotion, otherwise the others are financial upgradation Millers. Grade 4 and grade 7. The 1993 rules itself stipulate that year-wise vacancies has to be shortlisted.
Grade 4 and grade 7 are not financial upgrade.
No, they are promotion. That is what I have submitted.
Promotion.
They are promotional posts. What I am respectfully submitting for my lord's kind consideration, it has to be in terms of 1993 rules. The 1993 rules stipulate that year-wise vacancies has to be shortlisted. Gradation list has to be finalized by 1st April, and accordingly promotion has to be granted. From the past Millers, they have been shifting the dates of the promotion from the dates of vacancies also. In our gradation list also Millers, it has been mentioned that we have been promoted with effect from 2016, but the vacancies are rising from 2015 Millers, and that is borne out from the gradation list itself Millers. Page 92, I will just invite Millers. Page 92. That is with respect to the petitioner number 1, the other petitioners are also there. Page 92 Millers, may kindly have a glance. 92 Millers, it's a part of the gradation list Millers. At the top itself, the name of the petitioner is there, Millers. Anup Kumar Kesri, Millers. Kindly see the Millers, date of joining of the grade 4 Millers. That is 31st of 12, 2016 Millers. The second last column Millers. And thereafter, the tentative date of grade 4 Millers is 1/4/2015. So they are themselves treating it to Millers that I was eligible from 1/4/2015, but this is the joining date with effect from this Millers. And I am claiming this Millers. And earlier, what was the stand of the
Is
state?
there any law that the moment you become entitled for promotion, you have to be given promotion from that particular date?
Because so far that part is concerned, because it cannot be, because
Then
so far that Milords is absolutely correct, but what I am submitting for my Lord's kind consideration, there is a division bench also, Milords, on the point of interpretation of Rule 78 and 74 of the Milords financial rule, which prohibits Milords promotion with retrospective effect. The Honorable Division Bench, Milords, which has been upheld up to the Honorable Apex Court, Milords, while taking into account the KV Janki Raman and other ratios, where it has been held that for the fault on the part of
that's
the employer.
right.
Milords, it is the fault on the part which they are admitting.
The question of your entitlement would come only if any one of your juniors have been. You cannot have a right to.
Milords, that is my case present.
Which junior
Milords,
has been
that is our
promoted
case
and you have been left out?
Milords, that is what I am also coming on to, Milords. Milords, may kindly have a glance to Annexure 6 for a moment. After the judgment, what has been passed and how it has been decided and dealt with, Milords.
Yes.
Page 75 I am referring to, Milords. This is the order passed by the same directorate, Milords. Same issues were there, Milords. Now here what they passed, Milords, the concluding part of this, Milords, order, Milords, page 77. Page 77, the second, Milords, clause 4 जहाँ पे end कर रहा है वहाँ पे देखो. Milords, शिक्षकों की पारस्परिक वो ऊपर से प्रेस कर रहे थे. शिक्षकों की पारस्परिक वरीयता निर्धारण के संबंध में माननीय उच्च न्यायालय में स्वयं वाद में लंबित रहने के कारण प्रोन्नति बाधित रही, जिसके कारण माननीय उच्च न्यायालय ने अनेक वादों में स्वयं यथावत रखा है. दिस इज द ऑर्डर पास्ड बाय व्हिच आई वाज मेकिंग अ रेफरेंस. अतः ग्रेड 3, ग्रेड 4 एवं ग्रेड 7 में देर नियमित प्रोन्नति संशोधित वरीयता सूची के अनुसार पद उपलब्धता की तिथि से वैचारिक रूप से प्रदान की जाएगी. It will be only granted, Milords, with respect to, Milords, the notional date will be there, but the financial benefits will be paid, Milords, thereafter once I submit my joining. My claim is also to the extent, Milords, that once I am not placed, my date of promotion is not shifted back to the date of my eligibility, Milords, I will be losing the, Milords, further future promotion avenues also, Milords. I am not claiming the financial part as on date, Milords, because in the gradation list also, Milords, क्योंकि ये तो पूरा वैचारिक पे भी रोक लगा दिए हैं. Milords, may kindly have one more order which they have passed.
ये क्या है? ये जो आपने प्लेस किया पहले वो क्या है?
क्या हमने?
This is what?
This is the recent direction which has been issued, Milords. Page 135, which is in Pune, Milords. That is Milords is referring to. Because this is the recent direction, Milords, issued by the state government, Milords.
What is the date?
131, 5-10-23 का है.
कहाँ से हमको डेट मिलेगा?
Page number 134 पे हो.
134.
Okay, I'm sorry, Milords, I did not place the entire documents. This is the मार्गदर्शिका का उत्तर है. उसमें discuss and अनुलग्नक 1 है वो जो. And Milords, may kindly have a glance one more document, Milords. This is Annexure 6 as 7 I had referred to, Milords. After the Annexure 7 also, Milords, kindly have a glance to Annexure 9, Milords. That is 14/11/2022, Milords. By the same person, Milords, same authority. I am inviting, Milords, again to 110, Milords. 110, Milords.
In this decision, they have referred to the earlier decision.
Milords. No, Milords, they have not taken into account the entirety. And one more
No,
page.
they have referred to the decision dated 26/8/2021.
No, Milords. Milords, one more page. I will just invite, Milords. Page number 110 for a moment, Milords. For a moment, 110, Milords. Although the file is bulky, Milords, 110 for a moment may be seen, Milords. So for grade 4 to grade 7 is there, Milords. The first column itself, the indication is there, Milords. Page 135, if Milords is going across that zone. We are mostly concerned with, Milords, the first bindu and the answer reply to that, Milords, the guidelines issued.
Just
Milords, I'm sorry.
hold on for a minute. हाँ बताइए क्या बोल रहे हैं?
एक मिनट के लिए खाली 110 पे अगेन आई वाज जस्ट इनवाइटिंग टू annexure 9 पेज 110 because here again because the same secretary because he also takes into decision because after the orders passed by this honorable court and मिलोस में kindly see अतः उप के आलोक में निम्न निर्देश दिया जाता है हम पढ़ रहे थे उस दिन पहला वाला ही देखा जाए पद उपलब्ध होने की विभिन्न ग्रेडों में प्रोन्नति दी जाए वैचारिक सहित Here he takes a decision, Milords, in pursuance to the direction passed by this honorable court. Different directions have been laid down, Milords, and thereafter the same person, Milords, imposes a blanket ban, Milords. And Milords will appreciate that even the gradation list mentions that my date of appointment has to be vacharically at least has to be revised, Milords. Date of promotion, I stand corrected, Milords.
But now they say that as per the current
No, Milords, no, वैचारिक भी आपका shift नहीं करेंगे. We will not do it at any instance.
Yes, respondent, you have filed a contract. You take different decisions at different point of time, and while taking the final decision, you forget about the earlier decision. You see, you have given reasons as to why you want to give them retrospective promotion.
690.
Notionally.
Notionally.
Page 77.
Yes.
There is a full elaborate discussion because various orders were being passed by the court giving retrospective promotion and all consequential benefit. So you wanted to get rid of that. So you ultimately decided, okay, promotion was not given because of various pendency of the writ petitions. Therefore, notional promotion will be given and you will not give the financial benefit. He's happy with that because you see, by virtue of this order, many must have got the promotion. Now you take a U-turn and take a different decision. I'm sure many must have got
Because
promotion
many have
by
been,
virtue.
many because those orders are there because that is also part of record. Annexure 7 because page 78. Pursuant thereto because it has been shifted back.
If you want to nullify this order, then the order passed in the case of this, what was his name?
Because it cannot be nullified because it is pursuant to the order passed by the division.
Suppose if you want to nullify this, then in all the cases, orders passed in terms of Dinesh Chandra Mahato will
Because
be passed
Dinesh Chandra Mahato is
with
on
all
record.
consequential relief.
Annexure 5 is on record, Milords. The entire judgment is elaborate on that aspect, Milords. Interpreting Rule 58 and 74, which to a considerable extent prohibits, Milords. But does not impose a blanket ban, Milords, it cannot be. Annexure 5 लगा हुआ है Dinesh
The
Chandra Mahato.
learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the petitioner is aggrieved by clause Roman 4 at page number 135 of the writ petition, wherein the notional promotion to grade 4 and grade 7 has been denied. He submits that by taking the impugned decision on 5/10/2023, the authorities have not taken into consideration the earlier decision contained in memo dated 26/8/2021 in order dated resolution
Milords.
in order dated 26/8/2021, which was whereby decision was taken by taking into consideration various judgments of the High Court and also the judgment passed in the case of State of Jharkhand versus Dinesh Chandra Mahato, against which SLP was also dismissed. He submits that while the said decision dated 26/8/2021, it was decided to grant notional promotion, but financial benefit was denied. And it was also decided that those persons who were not in a position to join the promotional post, even notional promotion will not be given to them. The learned counsel submits that pursuant to the decision dated 28/6/2001, a large number of persons have already been given notional promotion, and by virtue of the fresh decision dated 5/10/2023, now the notional promotion is being denied to the petitioner. The learned counsel has also referred to another decision of the state as contained in Annexure 9 dated 4/11/2022, wherein the decision was reiterated that on account of availability of post, notional promotion will be granted. The learned counsel for the respondents is directed to seek instruction and file a counter affidavit by 30th April.
One more day.
One. 30 के बाद कौन सा शुभ दिन आया आपका? 8 तारीख. ठीक है? By 8th of May 2024, rejoinder 9th को रखते हैं. Post this case on 9th of May in the supplementary court list. नहीं तो अगला डेट में 2 महीना बाद फिर टाइम मांगेंगे.
Nobody ever लिखा गया हो. I am in less report number 4.
क्या करें?
Nobody ever requirement delivery point पर था not meant.
तो आप appearance record करते हैं?
मान.
चलिए भी serial number 9 में इनका appearance
10
record. 10.
order. I am in less report number 17.
उसमें add करिएगा. Later on, the counsel for the petitioner appears and he submits that his appearance may be recorded.
In view of judgment, my lord, pass your lordship in this criminal division 661 of 2020.
He submits that the revision is not maintainable in view of the judgment passed by this court in criminal revision number 661 of 2020. चलिए इनका लिखा.
Item 24 WPS 6743 of 2023.
Yeah, Mr. Rakesh Kumar, I am seeking adjournment for today only. He is out of station in a marriage ceremony.
क्या मैटर है जरा देखें.
This is a matter relates to Anganwadi Sevika, Lordship, and Excerpt 2 is under challenge, Lordship. The fact of the case is that this petitioner was recommended for appointment as a Anganwadi Sevika by the Gram Sabha, Lordship. And one respondent, number 5, who is private respondent, she was aggrieved from the Gram Sabha's resolution and said that she has a better educational qualification, so her name should have been considered, and she filed an objection, Lordship. After that, Lordship, the Gram Sabha was reconvened, and after reconvening of the Gram Sabha, the finding was again came to a similar fact that Sunita Nagesia is the fit candidate for appointment of as a Anganwadi Sevika, Lordship, and Kiran Tebra's name was not found fit on the ground that Kiran Tebra was not married lady, and as per the Anganwadi Sevika rules, a married lady's name shall only be considered for the that is the purpose. I am on behalf.
So ultimately, what happened?
Yes, Lordship.
Ultimately, she has been appointed.
Not given appointment. Annexure 2 has been passed by the respondent.
Annexure 2 is what?
Annexure 2 is again kindly have it. Annexure 2 page 24, Lordship.
पुनः आम सभा के लिए.
जी, पुनः आम सभा के लिए फिर से बोलते हैं, फिर से आम सभा कीजिए. ये चिट्ठी निकालते हैं जो 24/7/23 को. पहला आम सभा 14/6/23 को हुआ था और दूसरा आम सभा 19/6/23 को हुआ था विद द सिमिलर फाइंडिंग. अब 24/7/23 को फिर से आम सभा करने का आदेश देते हैं. ये
The learned counsel for the parties are present. The learned counsel for the petitioner submits that on 2 occasions in Aam Sabha, that is on 14/6/23 and 19/6/23, the name of the petitioner was recommended. But objection was raised by the private
Respondent number 5.
Respondent number 5, किस तरह से आपने private respondent number 5 with regard to the selection of the petitioner, he submits that the private respondent number 5 is unmarried
Yes, no, sir.
and therefore she is not entitled to be even a candidate for the purposes of selection of Anganwadi Sevika. He submits that this has been taken care of in the impugned order dated 24/7/2023, wherein the objection with regard to unmarried lady has been accepted, but instead of straightaway appointing the petitioner as Anganwadi Sevika, a fresh Aam Sabha has been directed to be convened. He submits that there was no occasion to convene a fresh Aam Sabha and there was no other irregularity. There was no irregularity or illegality in connection with the Aam Sabha in which the name of the petitioner was recommended. The counsel for the respondent state is directed to seek instructions and file a counter affidavit in this case. इससे तो इस ऑर्डर को तो प्राइवेट रेस्पोंडेंट ने चैलेंज नहीं किया,
नहीं किया।
तो अभी नोटिस का क्या काम है? करना है नोटिस?
कर दिया, जब हम लोग देख लेंगे, अपना कुछ जवाब देना होगा दे देंगे।
क्या जवाब देंगे? क्योंकि दिस ऑर्डर इज अगेंस्ट प्राइवेट रेस्पोंडेंट, एनेक्शन 2 इज अगेंस्ट प्राइवेट रेस्पोंडेंट, isn't it?
Yes,
Anyways, issue notice to the respondent number 5 at the address which has been provided in the supplementary affidavit dated 30/10/2023. Counsel for the petitioner is directed to incorporate the address of respondent number 5 in red ink during the course of the day. The requisites for notice upon respondent number 5 through speed post and ordinary process be filed by next Friday. 26 तक कर दीजिए, ठीक है? Post this case on 21st June, awaiting service report. In the meantime, the state should file counter affidavit by 9th of May. 9 तारीख तक आप काउंटर फाइल करें. Rejoinder to the counter affidavit of the state by 15th of May.
Item 25, WPS
File
6819 of 2025.
Promotion petitioner who is working as a legal inspector in CCL Lordship is come for promotion to the post of grade C, grade A, from grade B to grade A, because he was earlier in grade C. He has completed 5 years. Thereafter he was promoted to grade B, and thereafter
The matter relates to administrative criminal.
no
Central
administrative criminal, because CCL is also so here petitioner has approached CAT earlier.
So why this writ petition is to be entertained? You approach CAT?
Earlier there was a direction by the Honorable CAT, Your Lordship, to take a decision, Your Lordship. They have
So
not-
you approach CAT only. We will have no jurisdiction to entertain your petition. You had approached CAT earlier.
that earlier-
Where is the direction of CAT?
Annexure 1, Your Lordship.
ये हम लोग CAT के ऑर्डर के एग्जीक्यूटिंग कोर्ट हैं.
No,
Where
not
क्या?
asking for the execution of it. They have only said, Your Lordship, that
Where is it?
Annexure 1 is the order, Your Lordship.
Annexure?
1, page 21. There was a direction to take a decision on the representation of the petitioner.
We can't enter. This writ petition is not maintainable.
No, against CCL, Your Lordship, rates are maintainable because
आप CAT में गए, आपका
Yes.
petition entertain हो गया, तो अब हम लोग क्या करें? Do you want to say that this order is
No,
not
no, I'm
maintainable?
not saying that. I'm not saying
Okay.
that because the CCL is also the central government.
No, we do not. CAT covers CCL also.
Yes, sir.
Learned counsel for the parties are present. This writ petition has been filed for the following
Annex
relief.
2 is the compliance of the order of
It
the
appears
CAT.
that the petitioner had moved earlier before Central Administrative Tribunal for redressal of his grievance regarding promotion in OA number 51/968/2018, which was disposed of by the order dated 28/11/2018 within bracket annexure 1. The learned counsel for the respondents has submitted that the present writ petition is not maintainable as Central Administrative Tribunal has the required jurisdiction. He has also submitted that order passed by Central Administrative Tribunal was also complied. यही आपका कहना?
Yes, Madam, also compliant the order
That's
of
right.
the.
That's considering the nature of relief and the fact that Central Administrative Tribunal has a necessary jurisdiction, this court is not inclined to entertain this writ petition. Accordingly, this writ petition is dismissed. However, the petitioner may avail his remedy as may be permissible under law.
Item 26, WPS 6916 of 2023.
The case relates to the mutual transfer. There are two petitioners, they are working on the post of assistant teachers. Now they have made an online application. Their online
What happened? There is one more order
Yes,
which I have passed.
That,
उसमें क्या हुआ? LPA हुआ?
my lord, in this case, my lord has directed the state to seek instruction from the director of primary education to file a counter affidavit.
नहीं इसको तो हम decide करते हैं. ये pending नहीं हुआ. 6914 of 23 देखिए.
एक और है जिसमें representation was pending. That representation was ordered thereafter that order was passed. Now they are taking a plea that there is no provision of mutual transfer. I have annexed the circular of the government. There is a provision, and therefore my lord has directed them to seek instruction from respondent number 2 and file a specific counter affidavit.
हम तो लिखे हैं para 5 में.
Yes.
That there is a provision of mutual transfer as per clause 6.
Yes, and subsequent that order, my lord.
Against this order, they have not filed any appeal.
No.
You have not filed any appeal against this.
We are not aware of that order.
You are not aware. State को कुछ पता ही नहीं होता.
This matter is coming for the first time.
Maybe it is coming for the first time. It's a matter of transfer.
Yes.
Urgent matter, isn't it?
Well, it's normally with respect to transfer, inter-district mutual transfer. The petitioner is an assistant teacher. It falls within the zone of district cadre.
Page 51, they have rejected my application saying that there is mutual transfer application is not valid in departmental instruction. I have annexed the circular of the government. There is a specific rule, and therefore on the last occasion,
Learned counsel for the parties are present. Learned counsel for the petitioner submits that in WPS number 5821 of 2023, decided on 6 February 2024, it has been specifically observed by this court in the matter of mutual transfer of teachers within 2 districts that there is a provision for mutual transfer as per clause 6 of the circular referred to in annexure 3 series of the said writ petition, which has been annexed as annexure. इसमें कौन सा annexure?
इसमें annexure 3 series starting from page 28,
which has been annexed as annexure 3 series in the present writ petition. He submits that in view of the said provision, appropriate direction was issued by this court for fresh decision. देखिए तो WPS 5821 of 23 में कुछ वो हुआ है. आपको पता होगा, आप ही तो हैं.
हाँ, तो इसमें जो नहीं कोई की है.
It is reported by the counsel for the petitioner that no appeal has been filed against order passed in WPS number 5281 of 23. He has also referred to another order dated 28/2/2024 passed in WPS number 6914 of 2023, wherein similar issue is involved, and in the said case a counter affidavit has been filed wherein it has been stated that in terms of notification number 1556 dated 8/6/2022, there is no provision of inter-district mutual transfer. The said case is fixed on 23/24. अब fresh date कब है इसका? 6914 of 23.
24th April.
As informed by the learned court master, the case is scheduled to be posted on 24th of April. कोई supplementary list में है? देखिए. आप लोग के ऑर्डर से गया है? Adjournment order है?
Adjournment order.
दिखाइए जरा ऑर्डर दिखाइए. Posed this case on 24th April 2023 along with WPS number 6914 of 2023 in the supplementary cause list. उसमें you ensure that counter is filed.
Counter is filed.
In this case also, you say that
We are
there is
stating-
no
stating
provision.
the same provision. So that's 8 is to be seen that normally there is no such rule with respect to interstate, but in certain cases we can do that. It is pointed at page
If you
number
can do
29.
that in certain cases, then there is no complete bar, isn't it?
There is no complete.
Traditional rule will not taken what was remark post किए जाएंगे.
Okay.
That cannot be
In the supplementary cost list, दोनों रहे. If there is no bar, no complete bar, then you can consider and reject the
Yes, that can
representation.
be-
That is a separate thing. Right? Have you stated that there is no complete bar?
No, we have not stated.
We'll
But as
decide
per
it on that day,
any-
24th, in the supplementary list.
Next case also regarding.
Same case.
We filed the counter affidavit, we have rejected the claim, we are not saying that there is a bar. We are saying that he does not fall under the criteria fixed in the notification itself. We have stated in the counter.
In this case also you have rejected saying what?
There is no rejection, they have not given any rejection counter affidavit, they have not any given rejection order.
उसी दिन कर दीजिए दोनों.
Item 28
सब with
WPS.
कर दीजिएगा, है ना? We'll hear it on.
Item 28 WPS 7016 of 2023.
Initially, there were two prayers made by the writ petitioner. First, to give them joining, which was kept pending because of in the name of pendency of criminal proceeding, which has already been quashed by this one. Second was to make payment of salary and other emoluments which was payable to the petitioner for the period they have been kept waiting. Well, I got information about today only that the first prayer they have complied with the first prayer.
Okay.
That has been accepted. The petitioners have been granted both.
You are confining it to second prayer. Where is the order of LPA 26 of 19?
Page number 48. May I remind you, third landed counsel for the appellant state and landed counsel to the respondent to petitioners. The appellant state is agreed by in judgment dated 12/9/2018 by writ court in WPS number so and analogous matter, whereby the writ court has allowed all the matters
which related to appointment of class 4 employee in the district of Palam, giving specific direction to make appointment as per the condition stipulated in the advertisement. The present LP is barred by
The
limitation.
learned counsel for the parties are present. The learned counsel for the petitioner submits that during the pendency of this case, the relief as prayed for in para 1 within bracket 1 has been granted, and therefore he does not want to press the same. So far as relief prayed in para 1 within bracket 2 is concerned, the grievance is still surviving. Counsel for the respondents are directed to seek instruction in connection and file a counter affidavit in connection with the relief prayed for in paragraph 1 within bracket Roman 2. Let the counter affidavit be filed by this तारीख, ठीक है, by 30th of April 24. Post on 1st May in the supplementary test list.
Item 29 WPS 7054 of 2023.
Yes, petitioner.
I have challenged alerts annexure 5 alert, that is at page 108. This is the press release alerts which the respondent have issued, whereby alerts under the executive instructions of the respondents, the number of seats of the candidate has been reduced. Earlier also alerts one round litigation has been carried on before this approval.
You have challenged annexure 5.
Alerts.
Yes. So from where do you say that the available seats have been reduced? What was the total advertised post?
Total advertisement post
This
was
is in connection
annexure-
with that same Parasnath Mandal.
No. Annexure 1, page 33 is the advertisement alerts. Initially, this advertisement was for the appointment of constables in the JAB 2 to 10 months.
Page 33.
Page 33 the advertisement alerts.
Okay. Then
Petitioners alerts, they belong to district Simdega. Page 34. Page 34 alerts are pleased to come. Jila Simdega. The total seats alerts which was available for the district of Simdega was alerts 277.
okay.
Well, the petitioners alerts, they belong to the scheduled tribe community. So therefore, the total seat which was reserved alert for the scheduled tribe community was male was 19.
Okay.
19 is here alerts. The petitioner participated. They got qualified in their physical examination, in their medical examination, and the results were also published. Consequently, alerts, when the result was not published, alerts, then the petitioner they filed one writ application before this honorable court. Alert, the order is page annexure 6, page 112. This writ petition was dismissed, alerts, on the ground that the petitioner secured lesser marks, and in that writ application, the annexure 5 was not in challenge. So during that time, in that writ application, since it was not the prayer which had challenged annexure 5 alerts, and the prayer was only for the declaration of the results. So now the results were declared, and in that results alert, they say that we secured lesser marks than the person who have been appointed. So therefore, my lord, since we secure less marks, my lord, we could not have been appointed. Now, the contention which has been raised, my lord, that the total seat was 277. Now, results was published of 180. Consequently, by virtue of annexure 5, my lord, the number of seats that has been reduced so far as the tribal scheduled tribe candidates are concerned. So, had not the number of seats that would have been reduced, then definitely the petitioner would have qualified.
So the honorable
Where is
court,
Annexure 5 is not mentioning anything about Simdega.
Mallards. It is not about the Simdega Mallards. They have mentioned Mallards at Annexure 109. The Mallard will come to 109 Mallards.
Yes.
The
Okay.
Jila Simdega pooled 227 seats. Now, as I have indicated earlier, Mallards, Anusuchi Janjati, the number by virtue of this press release, they have reduced the number from 19 to 3 by the executive instructions.
Maybe that the calculation is wrong.
No.
No.
Calculation
What is the
not.
reason for this reduction?
So they say by the Mallard will come to the Mallard page 108. They have assigned the reason for reducing.
Yes.
प्रेस की विज्ञापन संख्या 4 और 15 दिस इज द एडवर्टाइजमेंट एलियर एडवर्टाइजमेंट के द्वारा विज्ञापित झारखंड संयुक्त आरक्षित प्रतियोगिता परीक्षा 2015 में जिलावार रिक्त में पुलिस मुख्यालय के पत्रांक 1419 पी दिनांक 22/9/15 एवं पत्रांक नंबर 1436 पी दिनांक 1/10/2015 के द्वारा कतिपय परिवर्तन किए जाने के कारण संशोधित जिलावार. So my contention, my lords, this is the reserve post, my lords, and the requisition which has been sent by the personal and administrative reforms, my lord. So far as the reduction and so far as the enhancement of the seats are concerned, my lord, that could have been only done by the personal department.
What is the date of the advertisement?
Advertisement, my lords. They have after that, after issuing the advertisement, they have done it.
No, we want to know that these two letters. Now you see, they are just a recruitment agency, right? Respondents are just an agency.
Yes.
They are bound by the requisition given by the government, right? Now the government has given a requisition. The government has issued these letters to change the vacancy.
There is, my lords, the advertisement which has been issued by the Department of Personnel, and so far
No,
as
advertisement has not been issued by Department of Personnel.
advertisement, a requisition has been made.
That a requisition
Has been made by the
Certainly.
Department of Personnel.
They can
and
change the
this-
requisition. Is there any legal bar?
Had they changed their requisition, my
They
lord,
have changed it because
No, but
it is referring to these
my
letters.
contention is letter Mukhyalay. This letter is of the
Yeah,
Mukhyalay. This letter is not of the personal department. So now, my lords, I am very much into the Article 320, my lords, so far as the change of the seats, my lords, so far the reservation of the tribals are concerned, my lords, scheduled tribes are concerned.
Your Lordship, so far this advertisement is concerned, Your Lordship, the selection process has already been over, Your Lordship, in year 2018-19. And now fresh advertisement has also been published, Your Lordship.
So what is this selection process is over?
Yes, Your Lordship.
Fresh advertisement including all the post has been issued.
Yes, Your Lordship. However, Your Lordship, counter affidavit has not been filed in this case. If Your Lordship will permit, Your Lordship, we will file our counter affidavit.
What is the date of this document which you have challenged?
Date of the document, my lord, Annexure 5.
There is no date.
They have not mentioned, my lords, even that was not known to us also, my lord. They don't mention the date, my lords. They send it to the website, my lord. Immediately they remove it from the website as well.
How can they remove it like this?
My lord, usually this has been, my lord, I should not make this statement, my lord, but usually this has been a tendency of even the JPSC and JSSC.
And you filed your writ petition in 2017 and your candidature has been rejected.
Earlier, my lord.
So,
Earlier, my candidature.
2017 your candidature has been rejected.
My candidature.
What do you want now?
My candidature has been rejected because, my lords, I secured the less mark for it during that time.
That's right.
And during that, my lord, when they filed the counter affidavit, my lords, we came to know about the Annexure 5. And in the earlier writ application, my lords, my prayer was not this. My prayer was, my lords, to declare the result because they were not declaring the result.
No, but it has been recorded that you have got less marks.
Yes. But my contention is, my lords, because since they have reduced the seats, my lords.
No, we can't do anything about it. This was issued way back in 2015.
Yes.
Now we cannot revisit the orders and pass it separately.
My lord, this is not with respect to the writ application. That writ application earlier was for the, my lord.
No, but it is very much there. Whatever be the list between the parties, it is recorded that you were not selected because you got less marks.
Less mark, and had I been, my lord, had the seat not been reduced, my lords, then we would
do
have
not
qualified.
know.
We would have qualified.
In 2017, you file a writ petition. Now you say that you have something new you have come to
After
know.
publication of the result.
After publication of the result.
And this was very much on the website of the
You
commission.
see, this point was certainly open to you to be agitated in the year 2017 when you filed
We
the
were
writ
not here.
petition.
When
What do you mean?
Before
You were
they
not
filed the
aware.
counter affidavit,
Just a
my lord, then we
moment.
came to know.
Just a moment. In the final result which was published,
My lords.
your name did not figure.
Figured, my lords.
In the result, your name did not figure.
My lords.
Right?
Because we
There
say,
were
my
only
lords,
3 ST candidates whose name was there in the final list.
Yes.
Right? So you knew
Yes.
that the result of only 3 ST candidates was declared.
My lords, the seats were 227 and the results were declared so far as only 180 candidates, my lords.
So
Only one candidate.
But still, in spite of that, in spite of everything, your writ petition was dismissed.
Because they were not declaring the result, my lords, since, and during that time, my lord, the writ application was not with this pair, my lords. In that, my lord, writ application was with a different pair.
Whatever points you wanted to take, you could have taken at that particular stage. Having that order, now it is not open to you.
Even
to
we were not aware so
reopen
far
it.
as this press Vigyapti, my lords. When we came to, my lords, when this matter was taken up, my lords, then during that time they filed the counter affidavit, and the counter affidavit they mentioned that since there is a requisition so far as the reduction of the seats are concerned, so therefore we have reduced.
That's WPS number 7054 of 2023 heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the present proceedings arise out of advertisement number 4 of 2015, wherein the total seats for Simdega district was 277, and for the purposes of scheduled tribe candidates, the total advertised post was 19. He submits that by the impugned decision as contained in Annexure 5, the total seats in Simdega has been mentioned to be 277, but for scheduled tribe candidates, it has been reduced to 3. He submits that once the selection process was advertised, there was no scope for making reduction in the number of advertised posts. However, he submits that earlier the petitioner had moved this court in WPS number 2426 of 2017, seeking a direction upon the respondents to publish the result of Jharkhand Constable Competitive Examination 2015, pursuant to advertisement number 4 of 2015, and to appoint them. But the said writ petition was dismissed upon a submission made by the respondent that the result was published and the petitioners had obtained less marks than the cutoff marks in their respective categories, and they could not be selected. The counsel, appearing on behalf of the respondents, has submitted that the selection process in connection with the advertisement number 4 of 2015 is over, and the posts have been advertised subsequently in connection with the available vacant post. He submits that at the time of
Only I will indicate your lordship. We issued your lordship if your lordship turn to page 16, your lordship. 68. Only I will indicate your lordship. that is under challenge, that is annexure 5, Your Lordship. My Lord, kindly see. We published the amended vacancy and the candidates were given option to make change in their application form, Your Lordship. And last date was also extended up to 15/10/2015. Can we have a para 3, Your Lordship?
The learned counsel for the respondent, by referring to the impugned amendment of advertisement, has submitted that the amended vacancy was duly advertised and the candidates were also given opportunity to make necessary changes in their application. The last date was also extended to 25/10/2015. He submits that it was under this selection process the petitioner had participated. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the selection process of arising out of advertisement number 4 of 2015, read with the amended advertisement as contained in annexure 5, wherein the last date was extended till 30/10/2015, is already over, and in the petition filed by the petitioner, being WPS number 2426 of 2017, it was submitted by the respondents that the petitioner had obtained less marks and therefore they could not be selected. The selection process being over, this court is not inclined to grant the relief as prayed for by the petitioner in this petition, which is accordingly dismissed.
Just one more point. After appearance, they can't challenge.
I am on a different point.
सही समय पे आप उस पॉइंट को मिस कर गए।
नहीं, उस वक्त
उसी समय चैलेंज करते थे वो।